35 polling matters, Democratic Alliance versus the Minister of Public Work and Infrastructure, AfriForum, and two others versus the President of the Republic of South Africa.
Good morning, everybody.
Good morning.
Thank you, Ms. Hofmeyr.
Justice Saldana, Justices, we are nearing the completion of the legislature's submissions. We had undertaken to the court to revert this morning on a particular issue in relation to Section 19. And as I indicated yesterday, my learned friend, Mrs. Zikalala, will deal with that. Before she does so, there are two matters outstanding from yesterday that I would like, with your leave, just to address swiftly. The one is I would like to make a correction to a submission I made towards the end of yesterday in relation to prayer 2 of the notice of motion. And then I would like briefly to respond to Mr. Katz's argument for the admission of the affidavit. Justices, on those two aspects, the point of correction relates to prayer 2 of the notice of motion, and the need for the correction arises from my reflection overnight that the question that Justice Slingers asked me about that prayer, I had not fully appreciated the force of. And so I would like an opportunity to correct an aspect which is a consequence of not remaining disciplined in distinguishing the mandates case from the Section 19 challenge. There are two causes of action in the DA's case. Both of those causes of action find expression in prayer 2 if they succeed on their primary arguments. So the DA uses prayer 2 both to invalidate the Expropriation Act if they succeed on Section 19, as I understand their case, and if they succeed on the Mandates Act. I made a submission about the framing of that paragraph, not including a to the extent that limitation. I would like to be absolutely clear as to where that point goes. That point relates to the Section 19 case. It doesn't relate to the mandates case. It relates to the Section 19 case because the reason why courts are required to declare statutes invalid only to the extent of their inconsistency is that separation of powers deference means courts must only declare invalid no more than is required to cure the invalidity. Our point about why prayer 2 should not be granted in this case is because the single 19.2 and 3 error that the DA's case is founded on is not an error sufficient to invalidate the whole act. You've heard us on that. It's discrete, it's limited. So at best for the DA in their Section 19 case, they can get the alternative prayer 4 relief because that is constrained to only those sections in which there is an error. Justices, when we move to the mandates case, I had said yesterday, the absence of a constitutional hook in their case for the mandates challenge is evident from the absence of language to the extent that in prayer 2. That was my error. It's not a framing problem in prayer 2 that is the undoing of the mandates case on our argument. The mandates case is undone on our argument because there is no constitutional hook. There's no provision in the Constitution that says mandates can only be given by provincial legislatures in plenary session. Once you don't find that provision in the Constitution, prayer 2 is unavailable to the legislatures. But I felt it absolutely imperative to draw that distinction because yesterday I suggested it was a framing problem in prayer 2 that undid the mandates case, and that is simply not so. The problem with the mandates case lies in the absence of a constitutional hook, which means they can't get into prayer 2. Justices, then swiftly in response to Mr. Katz and the admission of the affidavit from Minister McPherson, you would have seen that Mr. Katz and I differ fundamentally on the requirements of separation of powers. Our submission is that this court does not need to resolve that debate at all. And the reason why it doesn't need to resolve that debate when it considers whether to admit this very late in the day affidavit from Minister McPherson is because when Mr. Katz addressed you, he highlighted two requirements for the indulgence that is sought from a court when evidence is sought to be introduced late. He gave you the explanation for lateness and the prejudice considerations. Those are indeed two considerations, but they are not the only considerations. Critical amongst the factors is the materiality of the evidence. And I would just like to give the court a reference for that being a critical criterion. The decision is Mkhwanazi versus van der Merwe. It's a 1970 decision, volume 1, South African Law Reports, 609, decision of the Appellate Division, and the relevant section is at 626A to G. There are actually multiple considerations. I think there's 7 in the list produced there, but one of them is the materiality of the evidence. And what you did not hear from Mr. Katz is any answer to the second basis on which we submitted that affidavit should not be admitted. That's the law point. It's that it has no legal relevance because on the authority of Venetia Mineraria, submission can't cure a jurisdictional problem that there is no traditional ground of jurisdiction established by the applicant. Once that is so, and you heard nothing to the contrary from Mr. Katz, this affidavit should not be admitted primarily because it lacks any legal relevance, and if it has no legal relevance, it cannot possibly be material to the determination of this case. So that is my response to the admission of the affidavit, and with your leave, I'd like to hand over to Ms. Zikalala, whose job is probably going to be a little bit more detailed than mine.
Thank you, Ms. Hoffmeyer.
Justices.
Thank you, Justices. May it please the court, yesterday we ended our discussion with the question that was posed to me, which was whether the time periods in section 19.2 and 19.3 allow the parties to negotiate and reach consensus before the 180-day period begins to run. I propose to address the question, I will address the question that was posed to me, but what I propose to do is start by looking at the reading in remedy that has been proposed by both the President and Parliament, to recap on the existing reading in remedy, and then to explain where in the Act negotiation and consensus building is situated, in order to be able to then address the question that was posed. What I have done to be able to facilitate the discussion this morning is to extract the reading in remedy just on a single piece of paper, because I think it can be found in different places. So I just beg leave to hand this up. For my learned colleagues who are following on the case lines pagination, the reading in remedy can be found at paragraph 77 of the President's Heads of Argument, which is case line 018-185. Alternatively, it can also be found at the Legislature's Heads of Argument, paragraph 175, case lines 018-147. So, as Mr. Maneche for the President had already indicated, the reading in remedy has 2 limbs. The first limb states from the underlined words, when the mediation envisaged in section 91 is terminated without settling the dispute regarding the amount, time, and manner of payment of compensation, or, so or maybe let me just read the full sentence because it makes better sense if we read it in context. If the expropriating authority and disputing party do not settle the dispute by consensus or mediation, either party may, within 180 days of the date, and this is the beginning of the first limb, when the mediation envisaged in section 19.1 is terminated without settling the dispute regarding the amount, time, and manner of payment of compensation. That limb caters for the mediation aspect of section 19, which is sourced in section 19.1. That part of the remedy does not run concurrently with the 180 days, because it says without settling the dispute regarding the amount, time, or manner of payment of compensation. So that is if the mediation doesn't settle the dispute on compensation, then from that point, the 180 days would run. That part of the remedy is sourced directly from section 19.1, because section 19.1 states that section 19.1 provides for the mediation, which must be both initiated and finalized without undue delay. So it allows for that process in 19.1 to run its course. And if that process in 19.1 terminates without resolution of the compensation dispute, from then the 180 days would run. The second limb is from the word or. When no mediation is attempted, as envisaged in section 19.1, so this is when parties elect not to mediate. Where no mediation is attempted or envisaged in section 19.1, payment of compensation. I've just lost my place. Where no mediation is attempted as envisaged in section 19.1. Yes. Of the date of receipt of a written statement in terms of section 7.4A3, disputing the amount of compensation. So where we are. That second part, that is the second limb of it. That second limb is sourced directly from section 7.4A of the Act, where a party can submit the written statement disputing the amount of offer for compensation in terms of section 19. From the submission of that written statement, that is when the 180-day period would begin to run. So I just wanted to recap and explain the two limbs of the reading in remedy and how they are sourced directly from the Act. So the question then was posed in relation to consensus. In order to be able to understand where consensus is, one has to look at how consensus is dealt with in terms of the Act. For that purpose, I'd ask justices if you would go to the statutory bundle of authorities. page 14. Once a party has received a notice of intention to expropriate, we had already discussed this yesterday. Once a party has received a notice of intention to expropriate, in terms of section 7.4, they have three options that they can follow in responding to that notice of intention to expropriate, which has the compensation offer. Those three options are in section 7.4a. They can either accept the offer, so then we don't get into section 19. They can, in terms of sub 2, request further particulars under 14. And the one we discussed yesterday is 3, is that they can dispute. If a party chooses to request further particulars, then they go under section 14 of the Act. So essentially, Justice Saldana, a party receives the notice of intention to expropriate. That's the that has the proposed compensation in it. Rather than triggering the dispute mechanism, they can ask the expropriating authority to give them more information, to give them further particulars as to how they reach the amount of compensation. To cut a long story short, in terms of section 14.3, the offer of compensation remains in force until a revised offer can be made by the expropriating authority. So what section 14.3 contemplates is what we were discussing yesterday, the idea of negotiation. You first give me the offer for compensation, I ask for particulars, and then the expropriating authority can then revise the offer for compensation. That is where the negotiation part, attempt to seek consensus, is located in the Act. If that revised offer is then not accepted, that would then go back and trigger. You can then submit your notice disputing that, and that would bring you back into section 19.
Ms. Zikalala, 14 only operates if you want further particulars.
Yes.
Assuming you don't want further particulars, but you're ready to negotiate.
If you don't want further
No, you
particulars,
don't say, I don't need further particulars, I'm ready to start negotiating.
if
What
you
is-
yes, yes. I mean, if you don't want further particulars, but you're ready to start negotiating, well, then you can then engage the express. Let me just go back to 7.
19.1. Where you came to second.
Yes. Justice Saldana, section 7.4 gives you 3 options. And those options are made peremptory. You must do one of 3 things. That's the wording of the Act as it currently stands. You must either accept the offer, you must either request further particulars, or you must dispute. On the current wording of the Act, those are the options that are made available to a party. So you must exercise one of those 3 options within the 30 days.
So when do you negotiate?
You can either trigger the negotiation through the process of requesting further particulars
But assuming
and
you
then
don't,
ask, and then
assuming you don't want further particulars.
Justice Aldana, I can't take it much further than what is the express provisions of the Act. There are three options that are made available in terms of Section 7(4)(a), and those three options are either to accept the offer, to request further particulars, and then engage in a negotiation.
Because 19.2 envisaged a process other than mediation
Yes.
that leads to consensus. So we accept that there's two processes where there's a breakdown. The first part is a consensus hasn't been reached because the negotiations have broken down. Consensus, meaning it leads up to a negotiation, a discussion, but we can't find consensus. And the question is, that period of consensus, does that form part of the 180 days as it presently stands? And so if the intention of the legislation is to provide the parties the opportunity of arriving at a consensus, before you go, you trigger the 19.2 court mechanism. What are you saying to the party? How long do we need to be in this negotiating phase? But if you say to the party, the minute you reject, that automatically means the 180 days starts running.
Justice Aldana, we are, and I understand the question that you're putting to me in relation to the non-litigious avenues that exist in the Act for a party that might not necessarily want to be able to approach a court. At a first instance, one has to look at how the Act reads as it currently stands. And the Act provides for a party to either exercise one of those three options that are in 7.4 that we have discussed. Those options are not under challenge. That's not part of the case. It's one of those three options to engage in some form of consensus building there, and that can be done through the route of further particulars, through the route of requesting more information, then negotiating. Because if you don't need more information, or you don't want to engage the expropriating authority, then it's difficult to understand on what basis then.
Sorry, how do we make that assumption? Because you're not asking for further information, we don't want to engage. Assuming the person says, I'm ready to engage.
Or to make an informed.
Because you want me to tell you what my position is to your initial offer in the notice. Your initial offer in the notice to me appears to be wholly unreasonable. Assuming it's nil, I'm ready to talk.
There's an objection provision, isn't there, in terms of H? I just wanted to find out what, because it mentions 30 days as well. So, are you able to explain, in terms of time, when that's operating? Because that might address this concern. So, at 7.2H, the notice
Yes.
of intention to expropriate must include an invitation to any person who may be affected. I don't know if that's only third parties, I'm not sure. That's where the objections are provided for.
Yes. My reading of H would be in relation to the expropriation as a whole, and not necessarily in relation to, let's say, compensation. So it may be that a party doesn't dispute that the land may be expropriated, but where the issue arises is the compensation that is being offered. So I'm understanding it to speak to two different decision points. H.
So that's not part of what's envisaged in section 19, what is?
On my readings, H is not what is envisaged at section 19.
Is it, sorry,
When you refer to mediation in section 19.1, isn't that concept wide enough to include negotiations because it's the attempt to find parties?
Yes,
There's no definition of mediation in this particular act.
yes.
And if one looks at what the concept of mediation is. So does the concept of mediation in the act as it stands, is it meant to include the process of negotiation as well?
Justice Slingers, we would say that that would be a consistent reading of the Act. That would be a purposive reading of the Act because as I had submitted earlier, the Act intends to preserve non-litigious ways for parties to resolve the dispute. The Act intends to preserve that. And so the concept, and Justice Slingers, I'm indebted to you for this, that mediation itself is not a defined term in the Act. And so it is wide enough to encompass all non-litigious attempts to resolve the dispute. And once the parties have engaged in those non-litigious attempts to resolve that, and either one finds that they can't find themselves either by ways of consensus or by mediation in the way that we might understand it in the court or form of mediation, either party, the expropriating authority or the disputing authority, can then proceed to court if they can't find themselves there. But our submissions would be that you're reading that section 19.1 at least is wide enough to encompass all non-litigious mechanisms of resolving the dispute.
why do you have or in 19.2?
Because it doesn't compel a party to go through mediation. You can, so what 19.2 essentially says, if it only provided for mediation, it would mean that people would have to engage in that process where, and I think you were discussing it with my learned friend for the president, where it is a costly process and could be a costly process, but that consensus or mediation contemplates that there may be another way outside of mediation formally where you are trying to resolve the dispute, but if that process breaks down, then you're required to approach the court.
Just my sense is that 19.2 says very specifically or. So the parties, the dispute, the disputing parties and the authority do not settle the dispute by consensus. That's one process. Or mediation, that's an alternate process. All I'm saying is that the section 4 reference to 19 is to any one of the sections in section 19, not just 1 or 2. Problem is that once the gong starts going off at rejection and the parties or the disputing party says, but I'm ready to talk. But in the meantime, the gong is going off. Your 180 days are being shortened. And the only question is what provision is made for people in the negotiating phase in the same way that provision will have to be made for the period during the mediation phase, I expect by regulations. So those two phases or choices has to be regulated elsewhere. But the concern is that for the first process of negotiation, your 180 days is being eroded by the time there's this consensus-seeking process. So there's uncertainty about that. And Mr. Kalala, if you leave it uncertain, the lawyers will run rings for years in courts on technical issues. It'll be a technical issue about when does the 180 days start? And it will defeat the purpose of an efficient expropriation process. Now's the time to make it efficient. Now, you don't get a second bite at it, and the lawyers then start saying, but my client was in good faith negotiations. You didn't tell us that the clock was running. And now we only have 20 days in which to launch complex legal proceedings. Or we ask you to do so, because it cuts both ways.
Yes.
The expropriating authority might be asked, okay, fine, on the 90th minute, they say, start legal proceedings for us. And then the expropriating authority says, but we don't have enough time. We've got 5 days, 10 days. So the issue that I'm raising is, how do we make the process efficient? And the wording has to be efficient. It's not a principle issue, it's a practical issue. Nothing principle about. Principle, of course, is negotiations. The practical issue is that how do you prevent technical litigation around when does litigation start, or the period for litigation. And that's what you have to assist the court with.
Yes.
And you know, maybe I'm not too sure I can take it any further. And probably hear from the other parties, and maybe there might be some assistance. But I hear what you're saying, that the 90 days or the 180 days starts from the moment there's the notice of rejection. But that's 90 days, so it's 30 days in which you, as the person whose property is to be expropriated, fairly important decision. You only have 30 days to make that decision. That in itself is a very limited period for somebody who's facing null compensation. Someone who's facing null compensation, you've only got 30 days to accept it. And you can imagine invariably people who receive the null compensation are going to say, we reject. We reject. And the expropriating authority will say, well, let's talk about it. And I say, but we reject. And then they will say, let's go to court. And the expropriating authority, in an attempt to avoid legal proceedings, will say, let's talk. Let's see why you are rejecting that no. The process must be efficient. The only concern that I have about it is there's a lack of clarity with regard to how that efficiency arises if there's an uncertainty. And you have the opportunity to do so now.
Yes. Justice Aldana, I thank you for the question, and I understand the issue that you're posing to me. What I need to be able to do at a first point of departure is answer the challenge that has been brought to us. And the challenge that has been brought to us is not a challenge that the Section 7.4 period, the 30 days, may be insufficient for a party, or that there are not sufficient options in Section 7.4 to allow parties to negotiate those options. That's not the challenge any of us as the state respondents have been asked to respond to. The challenge that we've been asked to respond to in Section 19.2 and 19.3 is what is the trigger, is when does the clock start running? What is the trigger point? In order to be able to answer what is the trigger point, one has to be faithful to what the legislation already provides. The legislation provides for 2 trigger points. The one is the one at 7.4A3, and the second is the end of mediation. Those are the 2 points, those are the 2 trigger points the legislation expressly provides for. And those 2 trigger points are the ones encompassed in the reading in remedy that has been put forward. If at some later stage there is a challenge brought that there is uncertainty and vagueness in relation to anything else, then we will have to meet that challenge when it arises. But that's not the case that we've been brought here to meet.
I see as well, section 23 provides for extension of time on good cause shown. Is it intended to, I assume it applies in similar circumstances as well. It applies
Yes.
for any and everything provided for. That's how I read it.
Yes,
But they must show good cause,
yes.
reasonable in the circumstances.
Um,
So to the extent that there might be concern about
Time periods.
frames, it does list, it says, it's one of those provisions, it says may include circumstances at sub 3, and then it lists specific ones. I don't want to go in.
Yeah.
Yes, yeah, I think I'll leave it there.
Yes.
But it does potentially apply to this situation.
So the extension of time provision in section 23 does potentially apply to a party who might be feeling that they are unable to be able to meet the timelines in the Act. Another provision is section.
Section 23 only allows the expropriating authority to apply for an extension of time.
There's sub 1A, which is the owner applying, and then 1B, organ of state, and then sub 2 is the expropriating
Yes.
authority extending to itself.
Yeah.
Also
Yes.
the practice. But as it reads, an expropriating authority may extend to anything, which is
Yes.
text.
So yes. So yes. But in relation to section 19 in particular, it is notable that in section 19.4, it provides for an extension of the time periods in 19.2 and 19.3 on good cause shown. So that is the extension of time periods provision that applies specifically for purposes of section 19. Justice Aldana, Justices, then I just want to check if there's anything further that I need to be able to address. The one further thing that I need to address, and this emanates from the submission that had been made now by my leader, that's in relation to prayer 4. I just wanted to clarify. Prayer 4 is the alternative prayer in the notice of motion, in the DA's notice of motion, that asks for the declaration of invalidity in relation to the words in section 19.2 and section 19.3 of the Act. It, however, in the words framed in the notice of motion, it says, and I read specifically, alternatively to the relief sought in paragraphs 1 to 3, section 19.2 and 19.3, it adds section 19.4, but we've seen section 19.4. Section 19.4 only becomes irrational consequentially because of 19.2 and 19.3. There is on the face of section 19.4 no difficulty. So in potentially that respect, in seeking to apply to section 19.4, it may be overbroad in that one respect. It says the Expropriation Act is declared inconsistent with the constitution and invalid. And it then continues to say, to the extent that it requires parties to approach a court, here's the second part where it's overbroad. Within 180 days, there is no challenge before you of the time period selected by the legislature. There is no argument that has been made that the time period, the 180 days or 90 days provided in section 19.2 or 19.3 are in any way constitutionally problematic.
Isn't it a reference to the last part, the same topic?
Yes, but yes. So what I'm stating is that the quotation should not begin within 180 days. It should be of the date of the notice of expropriation. That is if one is to be faithful to declaring to the extent of the inconsistency, it is the notice of expropriation, that reference that remained in the Act that is problematic, not the period that was selected by the legislature for the delivery of that notice. So if the court, in granting its remedial discretion, is minded to grant Prayer 4 of the notice of motion, then we would request that it is limited only to those extents, in respect of 19.2 and 19.3, and that it is limited to the extent that it refers to notice of expropriation.
I understood 19.4 was simply what followed from 2 and 3.
Yes.
So if you fixed up 2 and 3, then 4
Then
fixes itself.
correct, Justice Salana, that's what we say. There's nothing facially on 4 that is problematic. It is made problematic consequentially because of the clerical error that was made in 19.2 and 19.3. Once the clerical error in 19.2 and 19.3 is corrected,
Sorry, it wasn't clerical.
Yes.
the consequential amendment, that's what I think. If the consequential amendment
Yes.
that wasn't made in 19.2 and 19.3 is corrected, then 19.4 is fine on its face. Justice Saldana, justices, those are our submissions.
Ms. Clara, thank you very much.
Judges, I'm requested by my colleague Manager for an indulgence for him to correct a submission that is made. Yes, for him to contribute to one of the points in the remedy. I'm not sure whether he'll do it now or maybe after my address, but I'm subject to the court's directions. Either we can deal it on those points.
Maybe after your address, Mr. Ogre.
That is, or it was just to offer an additional contribution on the consensus and mediation issue that was debated.
Very well.
Yes. So
You want to do it now or after
I'll
Mr.
do it
Ogre?
quickly because it follows on what Mr.
Certainly.
Kalala submitted. As we understand, the concern of the court is about mediation or consensus seeking post dispute. So where you have said, I dispute the amount, and now under 19.1 you can mediate, and under 19.2 it indicates that the legislation envisages that you could either have a consensus negotiation directly perhaps, or mediation where there's a facilitator. And the concern of the court, as we understand it, is why is it that the 180 days only starts running at the termination of mediation or when mediation is not attempted, but does not apply to where negotiation is also attempted post disputing? we would submit that when you read 2, it's clear that it envisages that you go to court after the failure of either mediation or consensus, and that 180 days should be frozen in respect of both. And that can be achieved simply by reading the remedy in this way. I make this submission conscious of the fact that the order is ultimately an order that this court finds just and equitable. It's not all of our proposals. The court can tweak the provisions. And so when you go to 2, it says, if the expropriating authority and disputing party do not settle the dispute by consensus or mediation, either party may, within 180 days of the date when the mediation envisaged in section 9.1 is terminated without settling the dispute regarding the amount. So mediation is carried through there, but consensus is not carried through. If you follow, you go on, reading, time and manner of payment of compensation, or where no mediation is attempted as envisaged in section 19.1, then the trigger is 7483. What is missing is that at the beginning of 2, it acknowledges that it can either be consensus or mediation, but when it qualifies, when the trigger starts running, it drops consensus and only mentions mediation. And the only correction the court needs to make is that where it says, when the mediation envisaged in section 19.1 is terminated without settling the dispute regarding the amount, time and manner of payment of compensation, or where no mediation or consensus is attempted as envisaged, then it won't be just as envisaged in 19.1, it will also be as envisaged in 19.2. Then 7.4a kicks in. That protects both the party that prefers to negotiate and the party that prefers to mediate, maybe for cost reasons. And so it's a partial answer on negotiation to go back to the fact that negotiation can start earlier. But there might be a party who at an earlier point doesn't choose to negotiate, instead chooses to dispute. That party is clear from 9.2 that is not deprived of entering negotiation after disputing, alternatively entering mediation. And for that to take place, the freezing provision, the provision that freezes the 180 days should be made applicable to both mediation and negotiation, and that solves the uncertainty the court is concerned about.
So you say
And
so are you saying adding in and when consensus is not reached?
or when consensus is not reached or is not attempted is the same. Really to cater for that consensus. It's not a material change to the proposal. The proposal is meant to protect mediation, but it leaves out the protection for negotiation, which the 9.2 already envisages must take place before one goes to court as an alternative. You're not forced to go to formal mediation, you can go to consensus seeking. So with those submissions in mind, and given that we're going to have additional time, we can we can make those textual additions to pick up consensus where it must be picked up and circulate it for the parties. So when they do reply, they have that in hand. They will say it's a 10th proposal. It's not a 10th proposal.
It's the 13th.
It's simply making this more equitable as between the disputing party who chooses negotiation as opposed to mediation. It's the same principle.
So
That's all I wanted to say.
Are we then recognizing 3 positions? 1 is rejection, let's go to court.
Yes.
2, rejection, but there's an opportunity to negotiate
Yes.
and find a consensus,
Yes.
with or without further particulars.
Yes. With or without further particulars, indeed.
And the third option is mediation.
Yes.
All of that will be regulated elsewhere.
Yes. And that is all housed in that section. And our learned friend for Parliament yesterday was quite reluctant to acknowledge that the proposal we made marries the DA's second and third alternative in their founding affidavit. It does. It just shows that it is suitable. Even the DA acknowledges that you can solve the problem, The only thing is they just listed them as 1, 2, 3. But you can combine 2 and 3 and have the solution. And I say this so that my dear friend Ms. Pillay knows that's our position when she replies. And I really, really appreciate the court's indulgence for me to come out of sequence. Thank you, Justices.
Thank you.
Judges, for a sensible treatment of the issues arising in this matter, and in order to place the matter in its proper context, the third and fourth respondents have delivered comprehensive written submissions. And having carefully listened to the submissions advanced on behalf of the applicants and amici, we propose not to raise our heads of argument or even to follow the sequence of the topics that are outlined in our heads of argument, but to highlight the main pillars upon which the third and fourth respondents resist the cultural challenge mounted by the applicants. And having in mind the division of work amongst ourselves and the time constraints upon which to complete the proceedings, we will associate ourselves with the submissions that were advanced by our learned colleagues, Mr. Manager, Ms. Hoffmeier, and Ms. Zigalala, to the extent where we are sharing common cause in terms of the topics that are advanced in our respective argument. We will also avoid, to the extent possible, not to repeat those submissions when we deal with the specific challenges as they were already being dealt with by our colleagues. However, judges, prior to advancing our argument in any meaningful detail, may the court permit us to make 5 overview but yet pertinent submissions. And in turn, those overview submissions will provide the court with a helicopter view of our main submissions. And the first one is the fact that the previous Expropriation Act of 1975, it's common cause that it was not aligned with the fundamental values, principles, norms, and standards apparent in our Constitution. And it definitely required reform in order to bring it in conformity with the new Constitution, with particular reference to Section 25. Justices, and that is the reason why in the preamble of the challenged Expropriation Act, in no ambiguous terms, it stipulates that the Act must comply with Section 25. Fundamentally, it says that it must comply with Section 33, which is a section governing a just and lawful administrative action. In addition, it also stipulates that the Expropriation Act must comply with Section 34 of the Constitution, which is the one that guarantees a person a right to access to court. It therefore follows that any official or administrator that has to implement this act would do so having in mind that whatever conduct that he undertakes meets the requirement of the Constitution in as far as it relates to a just administrative action, and also without in any way transgressing the right of a party that could have been impacted by such a conduct to have access to court. Those are fundamental when we are now developing a case towards addressing the specifics. Now, what is also important within the challenged act itself is the formulation in the long title, which my then colleague, Mr. Manager, had taken the court to. May I invite the court to also have a regard to the long title, as we wish to enrich and enhance the debate on other portions of the long title, which we submit that when interpreting Section 12 or Section 12.3, one should not lose sight of those important canons of interpretation. There can be no doubt, if one looks at the long title, that it provides that to provide for the expropriation of property for a public purpose or in the public interest. We want to emphasize those two because it's important that we don't lose them when we then isolate certain provisions out of context without giving the Act its proper context by saying that, by the way, what is the main purpose and what is Parliament seeking to achieve by the enactment of this legislation. And it proceeds, Justices, to say that to regulate the procedure for expropriation of property for public purpose or in the public interest. And fundamentally also it says that including payment of compensation. Now, those part of the long title, Justice Saldana and honorable members of the court, is that we should not stop reading the Act. We should not only start reading the Act where it provides for, where the provision of nil compensation may be just and equitable. Because by so doing, we are undermining exactly what the purpose of the Act is. The purpose of the Act and its main purpose, it's not simply to provide instances of a nil compensation, but nil compensation is catered for as one of those circumstances that might flow only when it is just and equitable to do so, and after all other relevant considerations have been taken into account. As the long title also, Justices references public interest and public purpose, it becomes paramount also not to lose those concepts when we then interrogate the proper meaning, extent, and content of the challenged provisions of the Constitution. And those two concepts must then be considered also within the unique historic context of South Africa, which is a country that seeks to address the inequities of the past created by apartheid system, and in order to ensure that the rights provided for in the Bill of Rights are not in vain, including the one which the Act seeks to achieve by land reform, and that is important. May I then invite the court also to have regard to the definition section of the Act. Simply to make the obvious point that the Act purpose, it's not a nil compensation when property is expropriated, but it also defines, and I'm sure that when the court pens down their judgment, it will not only single out that provision without having regard to the context and also the other relevant provisions of the Act. Public interest, it says that it includes the nation's commitment, that is very important. It includes the nation's commitment to land reform and to reform and to reforms to bring about equitable access to all South Africans' natural resources in order to redress results of past discriminatory laws or practices. That is critical in viewing the other provisions that are being challenged, to say that the focus of the Act and what it seeks to achieve is clearly articulated not only within those challenge provision, but also having regard to the context of the Act by having to give meaning to those concepts that are used, which are also aiding tools for the court to arrive at whether or not 12.3 indeed offends any right in the Constitution. Secondly, under the overview submission, Justices, is the fact that the Expropriation Act itself, it provides that compensation, and it says must be just and equitable, and must reflect an equitable balance between the public interest and the interest of those affected by expropriation. Now that follows that even when there is nil compensation, one must not lose what Section 12.1 provides for, what Section 12.2 provides for, and only then you go to Section 12.3. And you also interpret those sections without losing already what your long title tells you and what the definition section of the Act tells you in as far as it outlines and defines the most important central concepts such as public interest and public purpose. We therefore submit that one should not interpret or single out those provisions without really having context, firstly to the history of the country, and secondly to other provisions that are equally important in interpreting these sections. The third point under the overview submission is that what is revealing and slightly different in this matter as compared to other normal challenges where an act of parliament is sought to be declared to be inconsistent with the Constitution is the fact that the current matter is the fact that in the current matter, the section of the Constitution that entrenches the right to property also provides for a right or power to expropriate. It therefore follows that the right and power to expropriate, it's not merely founded in this challenged instrument, but it is anchored and finds its source within the Constitution itself. And that is one of the factors which we submit should not be undermined, because it's not as if this is an act that simply intrudes on a fundamental right without even the Constitution recognizing that important power or source of power where it rests. The fourth point under the overview submission is the observations that we have made, not only in the papers but from the submissions ventilated or advanced on behalf of the applicants and the amicus from Monday up until at least yesterday, is that when one interrogates how the Act is being challenged and its provision, no one even recognizes that you have to also have regard to other sections of the Constitution whereby we submit that Section 1A of the Constitution and Section 9.2 of the Constitution are sought to be those rights that are given cognizance to by the Expropriation Act. Because we submit that the Act empowers the state to expropriate property for a public and in the interest of in the public interest, and in so doing, it gives effect to Section 1A of the Constitution, which we invite the court to go to. as it provides that the Republic of South Africa is one sovereign democratic state founded on the following values, and this is one of the values that we want the court to take into account: human dignity, the achievement of equality, and the advancement of human rights and freedoms. And we submit, therefore, by statutes such as the one that is being challenged, that seek to give cognizance to those values, and that seek also to give that seek to improve on the questions on land and land access. One should not lose sight that by so doing, it also provides for the human dignity of those that were disadvantaged by the discriminatory acts. Equally so, we say that Section 9.2 is being given effect to by acts such as this one that is being challenged, because if you go to Section 9.2, it says that equality includes the full equal employment of all rights and freedoms. To promote the achievement of equality, legislation and other measures designed to protect or advance persons or categories of persons disadvantaged by the unfair discriminatory may be taken. And we are saying that the Expropriation Act must be seen as fulfilling also that important right in the Constitution, which is Section 9.2. Importantly also is that the Expropriation Act, its importance must be seen also with reference to Section 25.8 of the Constitution and Section 25.5 of the Constitution. Section 25.5 provides that the state must, and it says must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on equitable basis. We are saying that clearly when one scrutinizes or seek to challenge those provisions of the Expropriation Act or the Act in its entirety, we should not also lose sight of this constitutional obligation of the state. And we are saying this Act also fulfills that mandate and obligation. Equally so, we should not lose sight of Section 25.8. That says that no provision of this Act may impede, meaning that even 12.3 itself or any may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the results of past racial discrimination, provided that any departure from provisions of this section is in accordance with the provisions of Section 36.1. And we submit that clearly one should contextualize the interpretation of any provision and not simply to single out by not having reference to the other important sections or subsections of the Act. And the fifth point which we wish to make under the overview submissions is we caution the approach that has been adopted by some of the applicants and some of the AMQ when formulating the constitutional attack against either the Act itself or against the provisions or subsections of the Act, because such an attack creates distortions and it does violence to the canons of interpretation, where one simply take a subsection without referencing it to the other subsections where it is located, because by doing so, then you are distorting not only that subsection, but also you are not giving credence to the other subsections that are important. And we are referring here specifically to isolating 12.3 as if that is the main purpose of the Act, or as if it is the Act itself, and as if there are no provisions that clearly provides for compensation as formulated in section 12.1 and 12.2, and simply rest your challenge on 12.3. We are saying such an approach clearly undermines the canons of interpretation that ought to be involved when one is engaging with such a constitutional challenge. And secondly, under that very sub point of overview submission is that we have listened to a number of speculative examples that are provided in order to test the constitutionality of a provision. We find ourselves in a matter whereby you don't have an owner of land that is directly impacted upon by a provision of this Act, who is bringing a genuine constitutional attack premised on facts as to how is he or she impacted by a particular provision. Now the court then is forced to then entertain those speculative examples whereby we know that any provisions of the Act or statute becomes developed as and when parties approach the court with specifics, and the court are able to then develop and give meaning to the content of any other provision. And we are saying that therefore we are confronted with simply having to address these challenges in vacuum without the benefit of testing them against the true circumstances or the facts, which could give a far much more better credence to the attack. And furthermore, on the distortions that are being created by the attackers formulated is that there are instances whereby you see that the attack does not really rest on a fair, objective reading of the subsection or the provision itself, but whereby the applicants or the amicus seek to give a far much more different meaning to what they ascribe to that section. And that is why we have seen whereby concepts such as money and others are being given far much more due weight, even where they don't apply in the Act, simply avoiding to deal with the proper text and the language of the subsection or the section itself. We invite the court that there is in fact an approach which we find useful in one of the cases, and that is the case of Governor versus the Minister of Safety and Security. It is also contained in the bundle of authorities, the consolidated bundle of authorities of the respondents. It is those two bundles that were used by Mr. Maneche in his address to the court.
What page?
It's on page 963. It starts at page 959. However, we are placing simple reliance on paragraph 10 and 11, which are to be found on page 959, 963. We submit that this approach will be the approach that will assist the court in dealing with the challenges that are being articulated, and in also providing proper guidance as to the approach of interpretation when challenges of this nature are being mounted. Is the judgment of the Supreme Court of Appeal? I'm still waiting for Judge Slingers to find. Yes, there are two bundles. It appears on the second bundle as it continues from 790 up until the case of Govender. Yes. Paragraph 10 reads as follows. With the enactment first of the interim constitution and later of the Constitution of the Republic of South Africa Act 108 of 1996, and the vast changes it brought about to the juristic landscape, came a need for a method of interpreting legislation in a manner new to South African lawyers. I can do no better than to repeat and at the same time support the new approach as set out by Langer DP in his judgment in the Constitutional Court in the Investigating Directorate, Serious Economic Offences and Others versus Hyundai Motor Distributors Pty Ltd and others, in Hyundai Motor Distributors Pty Ltd and others versus Meet NO and others, 2001, 1 SA 545cc in paras 21 and 22, and the Honorable Court repeats the following. Section 39(2) of the Constitution, the provision in the interim Constitution was 35(3), provides a guide to statutory interpretation under this constitutional order. It states, when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote, and we underline that the spirit, purport, and objects of the Bill of Rights. This means that all statutes must be interpreted through the prism of Bill of Rights. All lawmaking authority must be exercised in accordance with the Constitution. The Constitution is located in a history which involves a transition from a society based on division, injustice, and exclusion from the democratic process to one which respects dignity of all citizens and all in the process of governance. As such, the process of interpreting the Constitution must recognize in which we find ourselves and the Constitution's goal of a society based on a democratic values, social justice, and fundamental human rights. This spirit of transition and transformation characterizes the constitutional enterprise as a whole. Then at 22, the court said the purport and objects of the Constitution find expression in Section 1, which lays out the fundamental values which the Constitution is designed to achieve. The Constitution requires that judicial officers read legislation where possible in ways which give effect to its fundamental values. Consistently with this, when the constitutionality of legislation is in issue, they are under a duty to examine the objects and purport of an act and to read the provision of the legislation so far as possible in conformity with the Constitution. Before we go to 11, we submit that that's exactly what we are submitting, that the challenged act and its provision, that's how it must be read in that context, understanding that it's important to give effect to the values and the spirit and the principles as enshrined in the Constitution. At 11, paragraph 11, it says that this method of interpreting statutory provisions under the Constitution requires a court to negotiate the shoals with the sealer of the old literalism and the charybdis of the judicial lawmaking. This requires magistrates and judges, firstly, to examine the object and the purport of the act or the section under consideration. 2, to examine the ambit and the meaning of the rights protected by the Constitution. And 3, to ascertain whether it is reasonably possible to interpret the act or section under consideration in such a manner that it conforms with the Constitution, i.e., by protecting the rights therein protected. And then 4, in such interpretation, 4, if such interpretation is possible, to give effect to it. And lastly, and if it's not possible, to initiate steps to a declaration of invalidity. And you can see that is only the last step upon which the court is called upon to have regard in interpreting the Constitution. I am told, judges, that it's now time for I'm told that it's past tea already. Would this be an
Certainly.
a convenient time to adjourn?
We adjourn. Mr. Mokoena, before you start,
Yes.
we've been alerted that the Emperor had his hand up
Yes.
just before we left court.
Yes.
So maybe I, in fairness, just give him an opportunity to say what he wants to. Good morning, sir.
This is the court, thanks for the indulgence. I'm seeing that, Honorable Justice, that we are not ready to finish today. I wonder if it would be possible to be granted indulgence of 10 minutes. Only 10 minutes. There are pertinent issues that have arisen from Monday until today that I would like to address the court on, which I think is very helpful in terms of moving forward. One of them is the issue of section 12.3. Why were those 5 factors reflected?
Emperor, do you want to address us on your contribution in this matter, or are they simply just procedural issues?
I wanted the issues that have arisen are not part of my papers, but they arose from Monday to today. But they are very important.
Yes.
Those are the 10 minutes.
So those issues, can they not be dealt with when you make your submissions to the court later?
If it's possible for me to address the court only today, then.
Well, we were going to just raise with the parties that if we get through all of the respondents today, perhaps I except for the EFF, but at least Mr. Mokoena and Mr. Masuku, if the EFF has any objection to us hearing the Emperor, and then the EFF, it's really up to you, and if that's possible. The EFF, to you, Mr. Kasiboto.
Judge, we had a discussion with the council for the ministers and the respondents coming before me. And our sense was that the EFF, given the time frames, is not going to address the court judge today. But when we return, in all likelihood, by the time it is close of business today, Mr. Masuku will be in his feet, if not Mr. Mokoena himself. So to to that extent, as a matter of principle, I have no difficulty with the emperor addressing for me. So to the extent I'm required to, I'm happy to defer my time to him, but more likely I will not have addressed this for today.
Good. Thank you for that. Let's see how far we get with Mr. Mokoena and Mr. Masuko, if we have any time left after that, if we can accommodate the Emperor. Thank you. Thank you, Mr. Mokoena.
Justices, having in mind the authority that we did read to the court and the approach which we say the court will find it useful to adopt in interpreting the challenged section or the act itself, we then pose a question to ourselves as to how should this act be properly construed or interpreted. We are mindful of the fact that what we have heard from the applicants and the amicus is an emphasis on only one provision, which is section 12.3. And that then leaves maybe the public with this misconception that this act, it's the act that has to do nothing else, that deals with nothing else but with expropriation of property without compensation or with nil compensation. And that's why we deem it prudent and necessary to then go through an exercise which we believe places the matter in its proper context. Prior to anyone arriving at section 12.3, which importantly are located only in a provision that provides for the determination of the compensation. That's not the act itself. Prior to arriving there, it's important to have regard to section 2.1 of the act. And we believe that's where we ought to start in interpreting the provisions of this section. We have already dealt with the importance of the long title, the importance of the definition section of the act, and what it seeks to achieve. Now, section 2.1 informs anyone that reads the act or any official of the state who may be the responsible official to implement the act or to exercise the power in terms of this act. The first thing that it informs him is that despite the provisions of any law to the contrary, an expropriating authority may not expropriate or cause it to be acquired under subsection 3 arbitrarily for a purpose other than public purpose or in the public interest. And we are saying that becomes quite important because then it demonstrates that one cannot conduct themselves in any form that is arbitrary when giving effect to the provisions of this act. Equally so, before you arrive at section 12, you then have the provisions of section 5 of the act that informs anyone that reads the act or anyone that will be enforcing or implementing the act that there is a chapter dealing with the investigation and valuation of property. And it then tells that at 5.1, the expropriating authority must consider all relevant circumstances when deciding whether to expropriate property and must ascertain. And then it gives you what must be ascertained. And at subsection 2, it says, subject to subsection 3, if the property is land, an expropriating authority may authorize, and this is important, a person with the necessary skills or expertise for the purpose of, then it demonstrates what might be required to be done. And in B also, it talks about the valuer to enter upon the land and any building on such land, and to do the necessary inspections and investigation for the purpose of valuing it. Those are critical because it demonstrates that the mindset is not only to arrive at a nil compensation, but clearly the Act is designed in such a way that there must be a balance that should be struck between the interest of the public and on the other hand, the interest of any person that might be impacted by the expropriation. And in subsection 3, it says no person contemplated in subsection 2 may enter the property without written authorization from the expropriating authority. Now that shows also structure of discipline, governance, and lawfulness upon which these expropriations will be conducted, and not simply as if this would then be equated to a lawful land grabbing. That can never be, because you see that within the Act itself there are those checks and balances, and the aim is not only to focus on the nil compensation, but to ensure that there are proper processes and there are rights that are protected, including those rights of impacted individuals by the expropriation. Equally so, Section 7 becomes critical because one doesn't go to 12 without firstly understanding, interrogating the other relevant provisions of the Act itself. On Section 7, 1, it says that it talks about the headings on the notice of intention to expropriate. That is equally important because one doesn't simply wake up and see that you have been thrown out of your property. There are processes. There is that notice of intention to expropriate, but also it tells us how it must be given effect to by those that will be implementing, the Act, and those that will be acting in their capacity either as the expropriating authority or those officials. It says that 7.1, if an expropriating authority intends to expropriate property, and in peremptory language, Justice, it says it must, it's important, serve a notice of intention to expropriate on the owner, mortgagee, and the holder of the right known to it at the time. Equally so important is that it must publish the notice of intention. This clearly demonstrates that it cannot be underhand, it cannot be done in secrecy, but people will be aware of what is being contemplated in every given time when a property is sought to be expropriated. 2A, it says that a notice of intention to expropriate must include, then A, a statement of intention to expropriate the property. We skip the others, they are equally important, but E, it says the reason for the intended expropriation of that particular property. F, the intended future date of expropriation. G is there, we place reliance also to H, where it says an invitation to any person who may be affected by the intended expropriation to launch with the expropriating authority within 30 days after the publication of the said notice. That is important. It demonstrates that even at the time when a party impacted upon by the contemplated expropriation, that party would still have a right to launch an obligation, to launch an objection. And it gives that party not only to launch that objection, but also to provide any submission relating to the intended expropriation. At that point, many things can happen, Justices. It may be that even if there could have been the intention to expropriate, but because of those objections that have been launched, and because of the submissions that have been advanced, it may happen that after those been taken into consideration, then the expropriating authority does not proceed. It doesn't follow as a matter of course that will always land at 12.3, but it demonstrates that this is a procedurally bound process and which ought to be complied with and adhered to. Why we are stressing these factors is because that when you read them in line with the long title that tells us, the preamble that tells us that the expropriating authority or its officials or that the act itself must comply. One of the things that it must comply with is section 33 of the Constitution, and that is now to adjust administrative conduct. And it means that if they fail foul of any of the steps or they take missteps, a party will still have the remedy to clearly say that, but you cannot proceed with expropriation because the act that governs you, you have not followed it, and my objections were not considered, or that I've placed submissions that demonstrate why maybe you may not even proceed with expropriation. Those will be considered. It doesn't follow in all instances that we have to locate ourselves in 12.3. The other important subsection is 4 of section 7. It says that a person responding to a notice contemplated in subsection 1 within 30 days of the service of publication of the notice must, and it says, deliver to the expropriating authority a written statement. And 4A3 or 4A Roman figure 2, it says requesting further particulars under section 14. That's also a right that is available. And subsection 3, disputing in terms of section 19 the amount of compensation offered, meaning that at that time the expropriating authority might, in the notice itself, have offered, or through the negotiations prior to the expropriation itself, having offered a particular amount. And that party, it's not bound by that amount, but it can still exercise those rights in terms of even disputing that amount as contemplated in the Act. And subsection 5 says that the expropriating authority must consider, and it says it must consider the statements contemplated in subsection 4, as well as any objections or submissions launched in terms of subsection 2H in deciding whether to proceed with the expropriation of property. Clearly, that will be the rights which may be exercised by those impacted by expropriation. Equally important is the Roman subsection 6. It says that the expropriating authority may decide to expropriate the property after compensation, the amount of which at the time and the manner of payment of which have been agreed with the owner, mortgagee, or holder, or approved or decided by court, subject to section 19A. That contemplates that it's not in all the matters of expropriation whereby there might be resistance, but there might be challenges, or there might be court processes. It may be that the person, the holder of the right, clearly realizes the importance of public interest, or the reason why the property is sought to be expropriated, and as early as that, there may be those agreements. It doesn't follow. And we are making this point simply to demonstrate that one should not approach this act and seek to declare it to be inconsistent with the Constitution by simply isolating the very same challenged clauses without giving cognizance to what we believe are quite fundamental, and for the public to understand and appreciate that there is more in the Act, and the Act is a genuine act of Parliament that seeks to give effect to land reforms, to restore dignity to people, and to address the inequities of the past. Section 8 of the Act talks about the rules of expropriation, and it tells you that in subsection 3, The notice of expropriation, it also tells you what it must contain, justices. Section 3G, it says that subject to section 20, the amount of compensation agreed upon or approved or decided by a court under the section. So meaning that even at that stage, we are not even yet at nil compensation as a preconceived or automatical a result that will follow. But we can see that within the built-in mechanism and having the scheme of the Act, that one would be having the compensation amount being agreed, not necessarily nil, but it might be an amount that's been agreed between the expropriator and the landowner or the property owner, or it might have been approved by the court, that amount. And that amount definitely will be approved by the court, premised on the constitutional standard that it should be past the master test of being just and equitable. So those we submit that are quite paramount to highlight. Subsection 4 says that the notice of expropriation served in terms of subsection 1 must be accompanied by documents detailing, and it tells you the date or dates on which the expropriating authority proposes to pay the compensation, meaning that you will have to read those in terms of section 12(1), section 12(2). Those will be the instances whereby there will be those amounts that are being reflected, and there will be the dates upon which they must be logged in within the process, demonstrating that they ought to be paid. When we submit that one should then have that context, Section 12 itself, I may invite the court to go back to Section 12 regarding Section 12 of the Act. It doesn't start at Section 12.3, but it starts at Section 12.1, and it is under the Chapter 5 dealing with compensation for expropriation. It is not the Act itself, but it's just part one of the provisions in the Act that governs the mechanism of compensation. How do we arrive at the compensation? What are the factors that ought to be taken? It guides the people that will be implementing the Act to at least have guidance that there might be different categories upon which a particular property might have to be considered when determining whether or not what form or type of compensation ought to be given, having regard to the circumstances and the facts of the case. Section 12.1 says that the amount of compensation must be just and equitable, reflecting an equitable balance between the public interest of those affected, which is important, including an owner, holder of a right, and a mortgagee, having regard to all relevant circumstances, including, it does not say limited to, but it says including, meaning that there will be other factors that might have not been contemplated in the Act, but which, if by having regard to those stages of objection, requesting of further particulars, and those that you have already dealt with, which might be relevant to be factors to be considered in determining that. It does not start with that expropriation would be, or as a matter of course, simply be a nil compensation will always be an outcome in all instances whereby one is determining the compensation. Section 12.2, in determining the amount of compensation to be paid in terms of the Act, the expropriating authority must, and these factors we'll deal with them when we now address the specific challenges. But they are there also as a guideline to say that the state must not find itself where individuals take advantage of the fact that they are agreeing to their property being expropriated, and in order to create, and they proceed to effect renovations which will distort what was initially contemplated to be a fair value of what was intended to as a compensation. And those are addressed not to say that there might not be instances whereby a owner of the property might demonstrate then what necessitated the renovations, but it just simply provide the guidelines upon which may be considered in order for one not to distort the amounts that could have been provided or simply to benefit from that exercise. We are going to deal with them when we deal with those things, but for now, justices, we want to demonstrate that you don't simply go to 12.3 without properly giving context to the Act, its purpose, having regard to the history of this country, having regard to a genuine, legitimate government purpose which this Act seeks to achieve, and which is land reform. And when you go to section 12.3, also it's only then where it says it may be just and equitable. And we should not undermine the words just and equitable as we are going to develop that argument when we are dealing with the specifics, because it's there for a specific reason. It finds itself there because one would have then to go back to section 2.1 that tells that you cannot do anything in this Act or expropriate the property through arbitrary means. And we now know you are also guided by other provisions of the Constitution which you must have to take into account, and you must then have to follow section 5, section 7, and other relevant sections of the Act in coming to 12.3. And we are saying nil compensation does not follow as an automatic compensation within the scheme of the Act itself, but it follows after a proper interpretation of the Act. Equally important, justices, in section 14 of the Act, because we have to highlight that there are indeed processes and procedures that ought to be followed, and the rights which the property holders are having in this entire exercise. A party that is impacted upon by expropriation may request further particulars. And we are told that in 14.1, the owner, mortgagee, and holder of a right may request an expropriating authority in writing to provide reasonable particulars about the offer of compensation, and particulars so requested must be furnished within 20 days of such request. Meaning that in this exercise, justices, there would have been maybe an offer. The holder of the owner of the mortgage and the holder of the right might have not been happy about what is being offered, and therefore he is entitled, in terms of the scheme of the Act, to invoke those provisions that entitle them to those procedural rights, including the request of particulars. And why are those important? They are important in the scheme of the Act because we are now told, we now know that in terms of the section, one of the sections that I've referred to, the submissions as well as objections must be taken into account. And it follows that from all those processes, one would have to ensure that they land up in a lawful and a just administrative action which does not even undermine the parties' rights to property, access to court, and to ensure that everything is done in terms of having to employ those mechanisms that are actually fair. And we are saying that we should give cognizance to those sections when we deal with the entire scheme of the Act. Equally, yes.
Mr. Mugwenash, 10 minutes is up, so you've been
Long up.
uninterrupted. Long up.
Long up, the honeymoon is long up.
Should have asked you early on with regards to
Yes.
the Constitution, but perhaps let me first ask you this because it reoccurs all the time. And when you've now dealt with 14 and 14.3c, and there's reference repeatedly throughout the Act and also in 25.2b
Yes.
for the compensation to be decided, obviously meaning there's been a dispute,
Yes.
or approved by a court.
Yes.
Why would it have to be approved by a court if there's consensus? You know, in the restitution process, the settlement of the parties or the proposals must go to a court for almost a stamp of approval. Is it anticipated that any amount of any amount of compensation, whether agreed, where it's agreed or proposed and accepted, must be approved by a court other than decided?
No, that's not how we read the section. We read the section to say that, in line with what our learned colleague Mr. Galala was saying, that the Act, and Mr. Manager, that the Act first contemplates a situation whereby, or encourages a situation whereby parties must engage amicably, resolve the issues amicably without having to go to court. Assuming that at a very first instance, the expropriating authority approaches the owner of the property and it says that, well, I've been also wanting to get rid of this property. There's no dispute between them. And they offer also the amount that is satisfactory to him. There's no basis to go to court. There's no reason, there's no dispute. And it then must actually be resolved at that point. But there might be a situation, and those is now the second scenario, whereby a party might be agreeing that the property must be expropriated, but not happy about the compensation that is being offered. Then there, it may be a situation whereby it ultimately gets to be resolved by the court in order to determine what would be just and equitable, having regard to the facts and terms of that case. But it doesn't follow that in all instances, even where there's consensus. Consensus means agreement. It means that the parties would have actually settled that in terms of the laws of compromise, there's no need to go to court, and those are our submissions.
So why does the provisions in the Act and the Constitution refer to approval?
I take the approve to mean it might be the approval by the expropriating authority. It might be agreed through the process, but it might then be approved by the expropriating authority to say that we agree on that matter. There will be consensus between the parties. That's how I see it.
Could I just raise this and
Yes.
anybody else can assist the court
Yes.
later in the proceedings? But the notion is because you're dealing with land, and land is a real right that is registered in the deeds office, and any change in respect of land rights must either be endorsed in the title deed,
Title deed, yes, we agree.
okay, or it must be, so, and therefore, that it's not simply just an administrative taking away, or whether by agreement or not, given that it's a title that's registered in the deeds office, and it's a real right, that you have to get notionally a stamp of approval by a court of an agreement even between parties. Is that necessary?
We understand that in as far as it relates to immovable property, definitely that process becomes necessary.
In respect,
But what I thought was the judge's inquiry first is that even when the parties have reached consensus, and I was simply addressing the question of consensus
Yes.
on the compensation that was agreed between the parties, whether in all instances, even though there might have been that agreement, then the court must still, pronounce on it. And I'm saying that no,
It's,
doesn't
it's
fall.
not an issue that arises from any of the challenges, but it's just
no, we understand.
because it relates to
We
compensation.
understand. We hope that it won't be raised in reply, but if it's raised between us and the court, we are able to give us what yes.
So whilst I'm with you, Mr. Mokoena,
Yes.
can I take you right back to the Constitution, because you, in your opening statement, you said it has to be interpreted in accordance with the Constitution, sections 1, and you referred very specifically
1A.
to 1A.
And 9.2.
Yes. Why have you left 1B and C out?
They're important because 1B says that non-racialism and non-sexism, because then that also, addresses the inequalities of the past, and equally important in issues of land reform, so that the very same issues are taken cognizance of. And even C, supremacy of the Constitution and the rule of law. We also submit that those are relevant considerations in one having to clearly interpret this act.
So just that B is important, particularly when it comes to issues of dispossession by way of race,
Definitely.
and that the Expropriation Act is not meant to entrench any racial
Yes.
dispossession.
Yes.
I think that's important to be
That's
understood
important.
and to be stated. But equally, with regard to women who've been disadvantaged by land dispossession in the past, weren't even regarded as being entitled to hold property in their own name, historically.
Definitely, Judge.
And therefore, it's important that it's also be done on a non-sexist basis.
Definitely, because then then it means that the land reform contemplated in the challenged act must also factor in, correctly so, 1B and 1C, and we agree fully with that. We stopped at A because clearly when we then address human dignity, it addresses everybody across the border, and also make sure that any dignity that could have been impaired upon by those land dispositions are being rectified. While we are on that same debate, there's another case which we want to bring to the attention of the court in relation to the competing interest, or whereby the transformation issues become paramount in order to not shy away from the history of the country and to make sure that we give cognizance to those rights. Is the case of the Bato star fishing case. We take leave to hand in the copies. And we find comfort in paragraph 76 of this judgment, simply to demonstrate that even on those examples, Honorable Judge, that were given about a person that might have owned 14 farms, and examples of those that might be having property merely to speculate, that there are in fact real issues which this act seeks to address, and there are cultural imperatives and obligations by the state in order to ensure that it give cognizance to the rights by enacting legislation such as the one that has been challenged. Paragraph 76 in the Bacho case, the Constitutional Court held as follows at paragraph 76. But transformation, it's a process. There are profound difficulties that will be confronted in giving effect to the constitutional commitment of achieving equality. We must not underestimate them. The measures that bring about constitutional commitment of achieving equality, we must not underestimate the measures that bring about transformation will inevitably affect some members of the society adversely, particularly those coming from previously advantaged communities. It may well be that other considerations may have to yield in favor of achieving the goal we fashioned for ourselves in the Constitution. What is required, though, is that the process of transformation must be carried out in accordance with the Constitution, as was recognized in Belporto School Governing Body and others, versus Premier, Western Cape, and another. And the following is quoted from that judgment. The difficulties confronting us as a nation in giving effect to those commitments are profound and must not be underestimated. The process of transformation must be carried out in accordance with the provisions of the Constitution and its Bill of Rights. Yet, in order to achieve the goals set in the Constitution, what has to be done in the process of transformation will at times inevitably weigh more heavily on some members of the community than others. Now it follows, and we understand the resistance to this act, because then if we are only concentrating on 12.1 or 12.3, you are saying that government must not introduce the act such as the one that is being challenged in order to achieve an imperative within the Constitution and in order to show that there is land reform. And there we have to weigh those rights of individuals that say that, but I've got my 14 farms or I've got a property in the northern suburb of Cape Town, which I want to put there merely to speculate, vis-a-vis the real interest of a person that wants access to a clinic, access to a hospital, or here who have to walk or run if they can for 15 kilometers or 10 for them to reach a particular assistance in a clinic or in a hospital. We have then to go back to issues like in Batu, whereby we can acknowledge those resistance that might be advanced by some that could have been from the advantaged communities vis-a-vis the goals which the Constitution seeks to achieve. We then say move also to section 19 of the Constitution to demonstrate that this is not an act all about, Expropriation Act is not all about the compensation for nil compensation, but it's quite an important tool, an important act which within itself it also recognizes and balances the rights of different parties. In section 19, it talks about mediation and the determination by the court, without even going to the debate of the time period, but simply on the principle level. All that we want to address is to demonstrate that you are still having what we call the court oversight, but you are also having the process of mediation that can be embarked upon by the parties. And there might be a number of results emanating from those processes. It might mean that even in instances whereby on a bona fide belief that this is a case of the land that ought to be expropriated, when the matter arrives in court and the court examines the scheme of the act and other things that ought to have been taken into account, there might be a judgment that is quite contrary to what the expropriation authorities believe, that would actually give cognizance to the right of a judgment in favor of the person owning the property, and also giving meaning to those other provisions that could have been undermined by the expropriating authority. So it does not follow that always when there's expropriation, you end up in 12.3, but there is, within the scheme of the Act, there are a number of issues that ought to be taken into account. Equally important.
Mr. McQueen, issue that you refer to raised one of the fundamental undertones in all of this.
Yes.
And the question was asked fairly by, it was AfriForum. Why should ordinary people be paying for land restitution? Is that not primarily the responsibility of the state?
The answer would be that if one still have in mind, I think it's section 26 that talks about regulations, and it may be that you have a framework that gives the principle as an act, but there might be those questions, even where the act says that whether there are those objections, then the person impacted upon by the expropriation may approach court, and if he's not able to do so, then he can call upon the expropriating authority to do so. Our reading simply means that that could be a broader framework, and then the regulations might then give far much more flesh to say in those instances who must then bear the cost of litigation, and those will be far much more clarified. But what should not happen at this stage is for us to debate all possible permutations when we don't even have a particular landowner or property owner that has actually launched such a challenge. And maybe within that challenge, one of the issues that will be relevant is that I want to challenge the conduct of the expropriating authority. I believe that I've got rights. I believe that this was done contrary to the act, but I don't have means. And we are saying we are now still at early stages of the act, but the framework is there.
Can I just take you back to this difficult issue?
No, definitely.
25.5 says land reform within the
Section 25 of the
25.5
Constitution.
of the Constitution. That's right. Within, are you there?
No, I'm not yet there. Section 25?
5.
Yes.
So the obligation is on the state to take reasonable legislative and other measures within its available resources to foster conditions for land reform.
Yes.
Why must those resources also include those persons who have property but are not using it?
Who have property but not using it. But then let's examine the language of, I think it falls within 12. I think it's section 12 to,
Or for that matter, any reason, whether they're using it, whether they're not using it, or whether they want to speculate,
yes.
or they notionally have no control over
No,
it.
we understand. We appreciate the question,
Yeah.
and that's why we are still going to deal with it when we deal with the specifics. But, Judge, let's examine the language of this, of how this is being coached, having in mind what we've already said about the approach to interpretation. And it says that it may be just inequitable for a nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances, including but not limited to. And all that you are saying is the following. Remember that you are having that process where a party may object, may provide reason, you might seek reason and all those things. It may be that after all that exercise, you then have to give far much more cognizance to the words, it may be just inequitable. And if, after taking all those relevant considerations into account, it is not just inequitable, it doesn't follow that there will be expropriation. But I'm saying that the emphasis must be on this constitutional standard, which we cannot escape, that it must be just and equitable. We understand just and equitable meaning that, one, it must be lawful. How is it lawful? It's lawful if we examine the other provisions, whether they've been fulfilled. Are there jurisdictional facts that exist for you to proceed with expropriation? And equitable, then, is it fair? Now, it means that you'll consider that, but also including but not limited to any other issue, which, Judge Saldana, you are raising, it will be a factor to be considered. And that's why we are saying that it's not a matter of automatic. It does not follow that then one party will ban on everything, but it's a process that we are having, and we are having all the rights that are built in within the Act itself, not only the rights of the state, but also the rights of those that are impacted by them. The other section that we want to highlight to the Honorable Court is Section 21. Section 21, which is important because we have had the parties simply going to 12.3 as if there are no other provisions that clearly demonstrate that even when there could have been the mechanism in 12.3 of simply determining the compensation. 21 says, notwithstanding anything to the contrary contained in any law, the expropriating authority may withdraw any expropriation from a date mentioned in the notice of withdrawal, if the withdrawal of that expropriation is in the public interest or a reason for which the property was expropriated, it's no longer applicable. It's important. Demonstrate that there are a number of factors that will have to be considered, but that you are having this expropriating authority that may, after receiving information, after interrogating a number of issues, on its own accord, come to the conclusion to say that, but maybe this is a expropriation that can be withdrawn, and why is it in the public interest to do so? And maybe the reason that initially existed so long are there. It doesn't follow that there will always be those negative and adverse and contemplated as being formulated in the attacks. The attacks are unfair in terms of they're not doing justice to the ordinary text of the Act, the scheme of the Act, its purpose, and what it seeks to achieve. Section 20. Section 23 of the Act also is important, Justices. And it demonstrates that we don't have a rigid form of expropriation which undermines individuals' rights, and it tells you about the extension of the time. And that becomes important because it might be that it offers the relevant holder or right or interested party that is being affected a further period, to determine other things that might be relevant or that he might want to deal with it while negotiating or while providing further information or while ensuring that the matter is being resolved amicably between the parties. And lastly, before we go then to the main attacks as formulated in Section 26, and we are saying that we are now at an early stage where unfortunately we are having these attacks. But some of the questions that might be lingering in the minds of the court, those are matters that we submit will definitely be dealt with in terms of the regulations, because 26(1) says that the minister may, by notice in the Gazette, make regulations regarding any matter that may or must be prescribed in terms of this act for its proper implementation, including administrative and procedural matters. So we are saying that those that might be not clear in terms of reading the umbrella provisions, there is still space to clarify them and to give flesh to them. And B, it say that any ancillary or incidental administrative or procedural matter that may be necessary for proper implementation or administration of this act. We therefore submit that those clearly are, or this is the manner in which we submit the act ought to be read, and not simply to ignore its context and its purpose and what it seeks to achieve. Lastly, under the overview submissions, judges, is the fact that we did carefully listen to the submissions that we made as they relate to international instruments or the constitutions maybe of other countries in the other jurisdictions of those countries. However, we have noted that those are made on the assumption that this act or our constitution not adequately addresses those subject matters, but importantly, whether or not those instruments take into account the unique history of this country that was subjected to an apartheid system, which distorted the rights of the parties, that discriminated against individuals, that did not recognize the rights of millions of the South Africans. And we are dealing with this act while there are still those experiences that are being felt as a result of that discriminating law. You don't simply apply international instruments without giving cognizance to the history of this country. And we cannot shy away from the realities of this country in as far as they reflect as to where land reside, hence where the land resides vis-a-vis the need to reform, to bring about land reform for public interest, which is critical to the values and spirit of our Constitution. And we are saying that also the approach that has been adopted simply to demonstrate that in the minds of many, the importance might be simply the benefit of obtaining money from this expropriation process vis-a-vis the important constitutional imperatives that are sought to be addressed and the land reforms issues that are sought to be given cognizance to. You cannot simply look at issues such as market value, money, amount, payment, ching, they follow, without giving cognizance of that. In our heads of argument, we're trying to extensively demonstrate not only the importance of the Act, but how in the agri matter, how the court also tried to strike those balances and to give effect to the rights that we are now talking about. And if we may invite the court to go with us to our heads of argument on page 020-145.
What paragraph, Mr.
From paragraph 175
7 of 9.
Are we there? Oh, yes. At paragraph 175 of our heads, we submit the following.
61 of 130.
While the applicants view the concept of no compensation and nil compensation as a distinction without a difference, the provision of nil compensation under section 12.3 and 12.4, we say that as anchored within section 25.2 and 3 of the Constitution serves a purpose. Fundamentally, it's 176. Section 12.3 and 12.4 straddle the fine balance of expropriating property in circumstances of non-compensation. It's not a foregone conclusion, but the result of a just and equitable outcome, having considered all relevant circumstances. Importantly is the references to the Agri case on page 177. Appreciating this challenge, Agri SA encouraged flexibility in approaching expropriation issues in different contexts. And in 178, Agri SA acknowledged that acquisition can take on various forms and cautioned against being too liberal or narrow in our interpretation, which risks undermining the constitutional imperative to transform our economy with a view of opening up access to land and natural resources to previously disadvantaged people. We keep on giving the references of the Constitutional Court judgment in the footnote, and that's what we have captured. And if you go to paragraph 179, you see that the applicants also argue that there are no guidelines from which to glean how exactly this is to be approached. Providing for nil compensation in terms of 12.3 and 12.4, in line with 25.8 and anchoring the process within section 25.2 and 3 of the Constitution, ensures that such approach is implemented under the standards and guidelines already provided for in section 25.3 in particular. In the event the court is not convinced with the utility in such an approach, but sees it more as a detraction from the prerequisite of section 25 and 3, we maintain nil compensation as provided for in 12.3 and 4. It's still within the parameters of section 25, 8 and 36. A similar point of appreciation was articulated.
Sorry, Mr. McQueen,
Yes.
I don't mean to quibble about words, but the concept is important.
Yes.
So you say, if we're not convinced with the utility of the approach, must the court not be convinced of the correctness of the
The
approach?
correctness. The correctness. Yes. We thought that we had license to language, but we realized that language is important. A similar point of appreciation was articulated in paragraph 89 of Agri SA, which was that locating the equivalence issue within the just and equitable compensation provision of section 25 has a deep resonance with, and we quote, historic compromise that section 25 examples. All that section 25 asks for is acknowledgement when pre-existing property is taken away by the state and allocated differently. When that acknowledgement is made, the previously advantaged may only expect fair and equitable compensation in the context of the need to redress past wrongs for what they have lost, not the equivalent of that loss. And I think that's important. We submit also that what is also clear from the above is that contrary to IRR's, the applicant's submissions, the previously advantaged owners are not entitled to equivalent of the loss they may have suffered, sustained / incurred. The key consideration is whether there has been a just and equitable compensation. We therefore reference 182 once more the judgment of Agri. It says that in the Agri-SA context, which the court humbly accepted was uncharted territory, the court had to go beyond the notion of compensation in monetary terms. The court explored and acknowledged the possibility of compensation in kind, and then proceeded to grapple with whether the compensation in kind provided for the MPRDA was substantially equivalent to a just and equitable compensation in terms of Section 25. We submit, honorable judges, that if you go even further to paragraph 183 and 184, and maybe if you can just read 184 and make submissions. Key to this case is the acknowledgement by this court, as in Agri-SA, that there is no harm in admitting that deprivation/expropriation distinction is merely conceptualization in legal terms, made in order to arrive at the conclusion of when compensation ought to be payable under Section 25. And almost invariably, the formal distinction in terms of legal analysis is based on a substantive notion of when it is just to pay compensation. That means that when it is possible directly to assess the justness and the equity of whether compensation should follow, it is not necessary to use the intermediate road of analysis. And we submit that premised on agree that one should be careful merely to locate the entire section or the entire purpose within 43, and that's why we want to demonstrate through that mechanisms and canons of interpretation, including what we're told by the Constitutional Court in Agri, that the court would have to take a far much more holistic approach, to take an approach that would always have to balance the fundamental imperatives of the state vis-a-vis the right of property owners, but also not to shy away from deliberately enacting legislation of this nature which seeks to give cognizance to labor reforms. Lastly, on this overview submission is that you were told also about how there might have been the disagreements and the agreements between the National Party and the ANC, and what there might have been the agreements there. But we are saying that we are here on a constitutional challenge. We are here now having an act. The test must be whether the provisions of the Expropriation Act in any manner are inconsistent with Section 225 of the Constitution. It is of no moment as to what were the discussions, the agreement and the disagreement. Equally so, it doesn't help the court to be informed that there might be officials of parties that have made statements pertaining to how they seek to amend the Constitution through an act. What the court must deal with here is what is before the court. We are having the act. The court can independently test the provisions of the act with the provisions of the Constitution. And that is the test, nothing more. Without all of those are simply atmosphere, and they don't assist the court in any manner. Even more importantly, we are saying that this is the act that serves a legitimate purpose of government. And therefore, even on the argument of rationality, it simply escapes one mind how we can come to a conclusion that an act that seeks to bring about land reform, to addresses those sections that we refer to in Section 1A, and Judge Saldana correctly so 1B and 1C, including Section 9.2, why can't those clearly be seen as giving effect to a legitimate government purpose? More so that they are located, this act is located in nothing more but in bringing those reforms. We therefore submit that even on the question of rationality, this is a case that is able to, in flying colors, champion and master the test in rationality as formulated by many. I'm about to deal with specifics.
Could I ask you just to pause and you recall I had a discussion with Mr. Manechi with regard to the words just and equitable.
Yes,
And what does that mean for administrators?
yes,
As opposed, it should mean the same to judges.
yes.
But what is meant by just
And equitable.
in the equitable? We'll talk about just now, but how would you explain to the
definitely.
administrator
Definitely.
what exercise and
Yes.
what do you bring to bear on that evaluative process?
Judge, in this long 5 days, as one was contemplating to argue far much more early, as I was sleeping, I would actually dream as if you're asking me this question. And I would wake up in the middle of the night to say that, no, it's not yet my turn. But having thought about it, and that's what made me to remember the case of Fed Shaw. And I want to read the judgment of Fed Shaw. We don't have a copy. As I say, it was simply in the middle of the night that I thought about it. And I thought that I saw Judge Slingers, I saw Judge Magnus Lockwood, and I had to wake up and say there is a judgment that can assist the court.
But you see, the point is that you're thinking about Justice Slingers and Justice Magnus Lockwood. I'm not here.
The face that I saw, it was your face. The Constitutional Court in Fed Shaw says the following, and it says that it's 1998, 12, volume 12. I have it from the BCLR 145 and the Constitutional Court judgment. I'll find the paragraph, but I've got the extract of the paragraph that I want to refer the court to. It says that it is a fundamental principle of the rule of law, recognized widely, that the exercise of public power is only legitimate when lawful. The rule of law, to the extent at least that it expresses the principle of legality, is generally understood to be a fundamental principle of the constitutional law. It seems central to the conception of our constitutional order that legislature and executive in every sphere are constrained by the principle that they may exercise no power and perform no function beyond that conferred upon by the law. At least in this sense, then the principle of legality is implied within the terms of 1993 Constitution, whether the principle of the rule of law has greater content than the principle of legality. It's not necessary for us to decide. We need merely hold that fundamental to the 1993 Constitution is a principle of legality. Important. There is, of course, no doubt that the common law principle of ultra vires remain under the new constitutional order. However, they are underpinned and supplemented when necessary by a constitutional principle of legality in relation to the administrative action. To the principle of legality is enshrined in section 24A. In relation to legislation and executive acts that do not constitute administrative action, the principle of legality is necessarily implicit in the Constitution. Therefore, the question whether then say that the various local governments acted ultra vires in this case remains a constitutional issue. Now we are saying to an ordinary administrator that will be implementing the act, the tools that you have asked my little colleague Mr. Maneche to say, where does he go? He goes to the act. That will be his guidance. And what is it envisaged by the question of Judge Saldana is that then, in as far as just, then they must act within the ambit of the law, meaning that their conduct must not offend the common law principle as developed by the Constitution of the ultra vires. So what is just is that just and equitable, it goes to the question of fairness. We are saying that having regard to those sections that we've spoken about, that we ventilated earlier on, Section 22, they must not conduct themselves in any arbitrary manner. Section 5, they must give cognizance to those rights, and Section 7, as we have developed them. Now, ultimately, it's no different from an official that is employed by the Civil Aviation Authority, who has to implement and give effect to difficult pieces of legislation and those regulations that are almost 6 or 8 volumes. All that they have as their guidance is exactly that. And therefore, this act calls upon them to act within the ambit of the law, nothing more. They don't have to interpret or to enter into any sophisticated understanding of the concept of just and equitable. Simply, at its simple best, they must act within the ambit and the confines of the law when they administer the act, and they must also demonstrate that they've acted fairly. I'm told that I am at the clock of 1 o'clock. Would this be an appropriate time, Justice?
Yes, but can I leave
But
you
we
with something?
can develop the question is.
I think it over lunchtime is that you're saying the administrator acts within the law as
Yes.
prescribed. And Mr. Maneki has developed and said the decision, for it to be just, must be able to be justified by the facts and evaluation of the
Yes.
facts. But there's this nebulous part of just and justice that just hangs out there. Different people may have different notions of what is justice.
Yes.
Is there any role for that notions to play as a value judgment in the evaluation process?
Yes. But
Because I can imagine there's no consensus, probably amongst many of us in the room today, as to what is justice.
before we go for lunch adjournment, and that is why this act says that the administrators are then obliged and bound, among others, by Section 33 of the Constitution. And therefore, we submit that, assuming that they have it all wrong, all is not lost. Because then it means that when it reaches the doors of the court with the tools that it having, it will be able to say that what you conceived as being a notion of justice or just, you may have actually not taken into account a number of factors, and look how adversely this has impacted. Those with the considerations to be taken into account.
Thank you, Mr. Magwena. Lunchtime. It's the best part of the day, I'm told. 1:15, everybody. Thank you.
2:15.
2:15. Otherwise, we'll have no lunch.
Otherwise, 12 minutes.
Yeah, and we also better listen.
Mr. Magwena, I thought I must just, because I started this probably unnecessary discussion about just and equitable. So let me just share with you a thought, and then I'm happy to move on. And so there's always a tension between justice and law. The two are always in tension. We saw it in the previous, under apartheid, law and justice, there's always a tension. And I suspect that tension continues, even with a constitution. And so just and equitable enables us to reconcile the tension in the act, in the law, in the statute, because it's a hard statute.
It is.
Expropriation is a hard measure,
It is.
but it's the law. And so the way it is mediated is through the constitutional values that you correctly pointed out. And I suspect that's what that just and equitable wants us to be able to do, is to understand that there's this tension between law and justice, but it requires a reconciliation between the very values in the Constitution, but more importantly, as it's so clearly set out in the Act, just and equitable. So I'll hold my peace
Yes.
if I simply just share that thought with you about how difficult
It is.
and complex this
Yes, and
issue is.
we won't pretend as if it's wrong. And that's why we believe that that's why the legislative team is necessary to provide some guidelines, as to what
Yes.
factors are to be taken into account. But also for the legislator to not say that this is the only thing that you may have to consider. And I think that in mind, it was having the very same concept
Yes.
of justice, that there might be other weighing factors that ought to be taken into account. We hear that. However, prior to advancing our argument, as we want to give you the main challenges, I am holding brave for those that will be flying back to Johannesburg, and they've promised to also pay my fees, whether Judge Saldana and justices may not be amenable to the request. You always don't shoot the messenger, but I will convey the message that we humbly request that we adjourn the court, subject to the court, obviously, authority at 3:30. It's a request because most of the flights are around 6 and 6:30, and we are also coming back to finalize the matter. That's a request. But the other thing is that now that it's towards the second leg of our hearing, Mr. Masuku might not be able to start his matter, his argument, and leave it halfway. I don't know where I will be around 3:30, but if I'm still on my feet, we request that we should adjourn at that time.
I think it's fine, but we wouldn't want at 3:10 Mr. Masuku to stand up
No.
and attempt to deal with his piece, because that's going to be disruptive for
Yes.
him. And we'll see what time we have, if any reasonable time for us to deal with the emperor, but that might also have to stand over to the next hearing. Thank you.
The second request is that we request the court to maybe arrange a case management at the time that might be suitable for the court, for us to have a virtual hearing meeting where we can synchronize our diaries pertaining to the next sitting. However, prior to that meeting with the court, the parties amongst themselves will have their own sideshow whereby they must see where they can locate or they can synchronize their diaries, and maybe can propose 3 different dates, and when we have the meeting with the court, we'll resolve it, because we can't imagine that we'll be able to resolve it now on individual basis, but we will make sure that we take it upon ourselves to assist the court as far as possible.
Mr. Mokoena, is it not simply just easier? We first have a sense as to how many days we will need, and then the parties amongst themselves discuss their availabilities, and simply just provide us with how many days. Give us two options, and we will then have to approach the judge president to fit that into our diaries, rather than a virtual, because We don't want to be, so if we simply have 2 sets of dates, we can then approach the judge president
That will be done.
for the 4th term, realistically.
We'll see what we. Then judges, as the roadmap to our main contention, you must have heard when my learned colleague, a good friend of mine, Mr. Maneche, threw me under the train to say that I'll be dealing with the specific challenges that are being mounted by IRR. And I will.
Just a minute,
Mr. McQueen, I'm just reminded that whatever arrangements are made amongst the legal practitioners, they've also got to arrange with the emperor
Yes.
so that his availability is also taken into account.
We will make sure that we.
Good, thank you.
We intend to contribute to the extent necessary to the section 19.8, which has been already ventilated, ably so by my little colleague, Mr. Maneche. But we believe that it might be important to highlight also certain features of the provision itself.
Did you finish your point about Mr. Maneki throwing you under the bus about section 12.3? What
Well,
was the conclusion of
that train, he said that I must deal with all the challenges that were advanced by IRR, those specific challenges. So I'll be dealing with them also in due course.
Oh.
Yes. So 19.8, as you understand it, judges, it must be dealt with having regard to where we will be in terms of the process at that stage. This is at the stage whereby there might not have been a dispute between the parties about the expropriation itself. It comes at the time whereby a court of first instance have already determined a matter pertaining to an amount of compensation that is just and equitable. And it only then relates to where a party might not be happy about the amount of compensation and thereby wishing to challenge nothing else but the amount. And we believe that that context is very important, because if that is the case, it then makes sense why one would not want to delay the expropriation merely because what is left is a question of how much a party might be able to obtain, more so in the light of the public interest issues that might be compelling for an expropriation to proceed taking effect. And you only leave what is remaining for the appeal court to determine whether you can get more from your compensation, or even in other cases whether you were overcompensated. And that's where we have to locate it. It is not as if maybe it finds itself whereby it is an appeal in a true sense, whereby the merits are being contested, the parties are not happy about the question of the expropriation, but here it's only on the question of the amount. We deal with this in our heads of argument on page 020, page 171, paragraph 286. We will simply rest at 289.
Is it not a superficial distinction? Some people might not want to agree to expropriation on account of the inadequacy, perceived inadequacy of the amount.
No, but, and that's why that is important, because it say, when we read it, it say that despite Section 18 of the Superior Courts Act, any appeal against the decision of a court on the amount and I think it's specific in that regard, on the amount of compensation. Now, it is not clearly, regarding the issues pertaining to whether or not my property ought to be expropriated or not. So at that point, a party might have agreed that his property might be expropriated, and there might have been all the processes and the box ticked in as far as the processes are concerned.
Why are you
And-
assuming the party has agreed to expropriation?
But I'm saying it may be that I remember that there are a number of instances where a party might, because here and in subsection 8, it does not address anything else but the amount.
Yes, but this person is at court now, but it doesn't mean that they didn't challenge expropriation before.
Yes, I agree with that, but 8 is quite specific. It's addressing nothing more, but because remember that a court at this stage, a court would have determined what is a just and equitable amount. Then what you are appealing is quite specific. It's a decision of the court on the amount and nothing more. So that's why we say that we have to give credence to that, because if that is the case, it then makes sense why you will have the expropriating authority saying that the expropriation must then proceed, so that the only issue that is hanging is a question of the amount that can be determined. And it might be so because there are much more compelling reasons pertaining to the property that is sought to be expropriated in order to fulfill that mandate of public purpose. And in that instance, the amount alone should not stand on the way of the government or the Supreme Authority having to fulfill its constitutional mandate. And those to us are sound, and they make sense why it's being phrased in this way. In no way does it temper with the judge's powers or the court's powers when exercising ultimately a challenge pertaining to any provisions of the Act, because the court at that stage will be at large to exercise its powers in terms of Section 18 and other sections of the Superior Court practice. We deem it necessary that we should actually emphasize that point, because then it makes sense why one at that point would say, well, the dispute is narrow, the issue that is remaining is amount, and therefore, why should we not go ahead with the expropriation? We are addressing that in our heads of argument and say in paragraph 286 that the challenge overstates the effect of the provision. Section 19.8 does not abolish appeals. It does not exclude court oversight. It expressly recognizes the possibility of an interim interdict, and that is critical. 287, the provision regulates the effect of an appeal on implementation. It reflects a legislative judgment and public purpose and public interest. Expropriation should not be automatically delayed by compensation appeals in every case. That legislative judgment is rational. Expropriation may be required for infrastructure, service delivery, land reform, or other pressing public purpose. An automatic suspension in every compensation appeal could frustrate the public interest even where the appeal has been prospects. And we are saying that therefore one cannot see in how, firstly, this section is inconsistent with the Constitution. At best, as my colleague have said, there might be then the comparing of two statutes, and you don't have hierarchy of statutes. No one says that the Superior Court Superior Court Act must take precedent over the Expropriation Act, but this would be a provision that can still apply regardless of the court's powers. The court will still be able to exercise their powers. The next section, which I am not sure whether it's still being advanced, it's section 19.7. I did not hear any argument. I did not hear any argument on 19.7.
Mr. Mokoena, just half a second on the 19.8.
Yes, yes.
Is that the threshold is very high. It's compelling reasons.
Yes, but I did ponder around the threshold. This envisages a situation whereby a party approaches the court with an interdict pendente lete, whereby on one hand you say, I want to stop this expropriation because I've got this matter which must now determine my appeal, my compensation on appeal. And therefore, nonetheless, a party that has to approach the court in order to stop that expropriation would still have to demonstrate to court their prospect of success on appeal. Now, if indeed on paper and on the face of the case that has been mounted as an interdict, it becomes apparent that this is a case that doesn't have any merit. And because it doesn't have merit, it should not be allowed to hinder the expropriation where it's required because of those compelling reasons. And that is the reason why then you have to demonstrate why the issue of an amount only must actually delay the entire process.
So there's two hurdles. The first hurdle is an application for leave to appeal.
Yes.
They've got to demonstrate that they've got a reasonable prospect of success. But also, if they want the amount, if they want the expropriation to be frozen as opposed, or suspended is the right word, you've got to jump through another hurdle of compelling reasons.
But it's in the same papers, the yardstick, if it's indeed a requirement in application for appeal to demonstrate, your prospect of success, it doesn't mean that through any other different means, you must also demonstrate that. Whatever that you're able to master as in your application for leave to appeal doesn't become any way different in demonstrating your prospect of success nonetheless. So that's our submission, that it doesn't, but assuming in the worst case scenario that it might be doing that, the challenge is far much more focused on whether or not does it take away the court's powers in the manner in which they deal with an appeal. But we are saying that challenge doesn't arise. The much more important question is that, does that render the section or the act to be unconstitutional? We are saying that no. We are here because we have to come and answer a constitutional challenge.
Could I just ask, would null be a compelling circumstance? Will null be a compelling circumstance?
It may be.
Maybe.
Yes. The court will have to deal with it on those bases, on whatever reasons that might be brought, yes. And it might be compelling if a party wants to demonstrate that it's not really an outcome of a just and equitable remedy or process undertaken in the Act. 19.7, there was no argument on 19.7, but 19.7 says that where a court finds that a provision of this Act
Sorry, Mr. Mokoena. Could we just get clarity? Mr. Mokoena asked, was 19.7 still alive as a challenge? And there was a murmur that said, in our heads. Is there Vaderland Stichting and AfriForum? Mr. Mr. Abenga?
Yes, it is raised in our heads, I think very briefly. Of course, there's no relief that we connected to Section 19.7. It's not an independent challenge as such in the notice of motion. So it can be dealt with very briefly if I wish to address it at all.
We're in the same position.
Thank you. Thank you, Mr. Is anybody else? Good, thank you.
It says a court may, it says that where a court finds a provision of this act not complied with, it may make such an order as it considers just and equitable, having regard to all the circumstances, including that it lists them. Now, importantly, this regulates a conduct of the act itself. It says where a court finds that a provision of this act, it's not a challenge where you are saying that a provision of the Expropriation Act in any manner offends a provision of the Constitution. So that's the first submission that we're making, because it has to deal with what is happening within the act itself, and it says it may make such an order, but not that it must actually make any order. It may make such an order as it considers just and equitable, having regard to all relevant circumstances, meaning that the list is not only A up until D, but the court must also consider what is just and equitable. And we submit that we don't see how that offends the Constitution, how that in any manner impact on Section 1721A. The court will still be at large when there are constitutional challenges or a conduct that's being challenged to make or provide a remedy as in force, F-O-S-E, in the force matter, where it can fashion any relief in order to give effect to the rights entrenched in the Constitution, or to declare any conduct to be inconsistent. We don't see the merit in the challenge. Our heads of argument are dealing with that challenge on page 020-178 on paragraph 317 to page 020-97 paragraph 326. We don't have to read them because I've tried to summarize them as best as I can. The next challenge has been dealt with my new colleague, Mr. Maneche. It was the challenge pertaining to 12.2D and 12.2E. We are addressing that challenge in our heads of argument, page 020139 to paragraph 151 to page 151, paragraph 157. If I may take the court to those pages, 020139 and the paragraph that we find relevant, if I'm reading all of them, is paragraph 151. We see that notably, section 12.2 set out a list that must be considered when determining the amount of compensation. It is not a closed list and is subject to the just and equitable standard. This is expressly stated in section 12.2 of the Act. 152. Accordingly, the circumstances set out in section 12.2D and 12.2E would only be considered if it is just and equitable to do so. This is consistent with section 25.3 of the Constitution. 153. Section 12.2E is a valuation control provision. Its purpose is to prevent the compensation inquiry from distorted by artificial, unlawful, speculative, or opportunistic factors that do not properly form part of just and equitable compensation. This section is intended to take into account that property owners may effect unnecessary improvements or contrived value-creating steps in order to inflate the compensation amount. So what are we saying? We are saying that let's look at the mischief which the legislator seeks to address by enacting 12.2 and 12D. And remember that in all this exercise, a party would still have a right to approach the expropriating authority with information that can demonstrate anything to the contrary that ought to be taken into account. And 12.2E, we then submit that provides for those circumstances that could have not maybe enlisted in your 12D, and as such, they complement one another, but they are not in conflict with one another. And the other challenge that we want to simply contribute to is the challenge as it relates to section 12.3E. Section 12.3A. Section 12.3A, on its fair reading, it says that it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances, including but not limited. And A says that where the land is not used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from appreciation of its market value. We are saying also this must be read in terms of, with reference to what the Act seeks to achieve, the pressing issue of government to develop the land to the benefit of those that were disadvantaged, and to weigh those factors and of the land owner vis-a-vis those objectives that are sought to be achieved. We are addressing this, Honorable Court, from pages 020, page 154 of our heads of argument, at paragraph 208. We will read only 208 to 11 because they address the point. We are saying at paragraph 208, the allegations made by AfriForum and IRR are wrong. Section 12.3A does not punish ownership, non-development or investment. It identifies one circumstance under the current democratic and constitutional transformative dispensation that may be relevant where land is not being used and the owner's main purpose is to develop the land. It's not to develop the land or use it to generate income, but to benefit from appreciation of its market value. Even then, nil compensation, it's not automatic. That's what the page was saying, that section 12.3A seeks to inhibit arable land or other land that could be used for a social productive purpose, such as housing, from being used and held solely for the purposes of benefiting for the appreciation of its market value. It encourages making effective use of all land. It is not targeting land that is being held purely for investment purposes, but instead aimed at expropriating land that is being held for no reason other than to benefit from a profit, other than to obtain a profit from expropriation. already substantiated above, Section 12.3 still requires all relevant circumstances to be considered in deciding whether nil compensation would be just and equitable. Section 12.3a does not prescribe that where land is being held purely to benefit from its market value, and that nil compensation will in that circumstance necessarily be just and equitable. This is just but one example of a circumstance which the legislature considered requires taking into account in the land reform context. And we submit that the rest of the argument lies there. We are saying that nothing in that section clearly offends the Constitution, and that there are weighing factors that will be taken into account, and that exercise will only happen if it is indeed just and equitable to do so, having regard to all the factors that has to be taken into account.
Mr. Mkwena-Grace asked a short question.
Even the long one, Judge.
So you say the section is not to punish non-development, investment. And the investment here is a speculative investment on the market.
Yes, ma'am.
So the reality, it targets that land which is simply been held for speculative purposes.
Yes. But it targets it only if indeed at that time it should have been identified, for the purpose why it's been required for. And after one have exercised also that task within the Act itself, in order to weigh the compelling or the competing interest, whether or not if one have the public interest consideration vis-a-vis that land that is there. And we have tried to also demonstrate that there might be a pressing need at the time of those of that land reform to take place in order to benefit those that might be requiring access to land, access to clinics, access to hospital. That will be a weighing factor of all those considerations. But it does not mean that it's merely targeted simply because it lies there for speculation. It must always be related to the purpose of which is being sought to do that. There might be properties that are being there which an owner is merely holding, it's merely to speculate. But if there's no public interest that can be demonstrated or a need to target that piece of land, then or piece of property or land, then the expropriating authority will not do that. It must always be brought back within the ambit of the transformative agenda of the state, the purpose for which expropriation is sought, and whether or not what are the greater benefits that are sought to be achieved in terms of the land reform imperatives. We don't agree or even support any contention that says that there might not, in South Africa, there might not be people who might be holding land where they want simply to speculate it, and that land doesn't fall within any land which are required for that specific development. There'll still be people that will be able to do that, but the question is that this one that might be targeted, it might be targeted for that particular purpose that the government seek to achieve through that land. It's not every land that people is holding for speculation that will be under attack. That's not how the Act. That's not how we read the Act.
And when you say for that purpose, what are you referring to here? Because there are a few qualifiers. It says in the public interest, taking into account all relevant circumstances. So how does a person who owns this type of property, land, know whether or not they're a target?
Remember, Judge Lockwood, at that time there would have been, remember the sections dealing with the investigations. where there might be people that have to come to land, and there are issues of notices that would have been taking place. When we arrive at this stage, and maybe that's where we have to really keep on making this point. Section 12 locates itself within the determination of compensation. But at that time, there are a number of things that would have actually taken. And the question that you're asking, those are the questions that would have been determined if one have to those processes that you've referred to from section 5 of the Act, investigations and gathering of information for the purpose of expropriation, and that will ultimately lead to section 7, meaning that when you receive that notice, all those information and documentation will be known to the person whom the land is going to be expropriated. He won't be caught by surprise. The only thing with 12, it will be now the question of determining the amount in the light of all those other steps having been undertaken. So it doesn't mean that you would not have information, you would not have requested for information, you would not have actually objected. All of those would have. Section 12 is the determination now after him receiving notice and being aware that his land is earmarked for those developments.
Yes, I didn't understand the challenge to be about the timing. I understood it to be about it's almost, even the way you're describing it, it's almost as if the owner is placed on in a position where they have to meet a reverse owner because they receive that notice in terms of section 7. There's an investigation in terms of section 5. There's a notice of intention to expropriate in terms of section 7. You've asked for information, you've got the information, you're still not happy. You're not happy that your land is included in this provision. But the expropriation authority insists that you are probably the object of 12.3 because of the manner in which this is drafted. I'm trying to ask about the concept, not so much the process or the stage. How does this owner know whether or not they're going to get out of it? They never know because the expropriating authority might say, oh, it's in the public interest. Or they might say, oh, we've taken into account relevant circumstances. That's really the issue I'm asking about.
No, but I am trying to get how the challenge is being phrased. But maybe we can just do justice by reading 12.3 as it is, Justice Magnulo could, because we
You asked me to read?
No, maybe we can read section 12A, 12.3A, now that I don't find the challenge. How we understand or how we would implore the court to read 12A. At 12.3A, it says that it may be just imputable for a nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances, including but not limited. And our starting point, it's not the 12.3A, and that is why in the morning we are at pains to demonstrate that if we can locate the challenge by merely isolating the provision and seeking to make that provision to be an act itself, it might actually create distortions. Our understanding is that at this point, it's at the point of the determination of the compensation. But it doesn't mean that this would be the first time when the landowner then knows about the fact that his land or her land is targeted for public interest. that must have actually followed a number of steps and stages. And that's why we're cautioning against how the attacks are formulated. We are saying that as at that time, one envisages that what is contemplated in Section 5 would have taken place. And that would be those investigations and the evaluation. And that would not happen without the landowner knowing, or the holder of the right to know. And clearly, if it might happen that it doesn't know, but you can see that from 5, it tells you that what are the things that you must consider, the experiment must consider, and also it states that the fact that there might be even experts that are being employed to go into that land that is being sought to be expropriated. At that stage, the landowner will also be aware. And if it might happen that you say that you're not aware, but we are saying that the expropriating authority then would not escape determining those amounts without firstly having had to give a notice in terms of Section 7. And that notice also stipulates what should be in the notice. That notice is meant for who? For the person that will be impacted upon. Now, Section 12(3)(a) must rest from those provisions. At this stage, the only component that will be left will then be the question as to what would be the compensation if it's being expropriated in the public interest. These are the factors to be taken in determining the compensation, not process-related issues which ought to have been communicated or dealt with the knowledge of the landowner. And that's how we understand it. But once you take 12(3) out of the scheme of the Act, yes, you might lead to the question that have been posed being genuine, because then you are only looking at this section in isolation with the other built-in check and balances and remedies that are available to the landowner.
I don't understand the answer, because I thought, you must correct me if I'm wrong, that investigation must include an offer of compensation, must end up with an offer, not so. I'm asking.
Yes.
Yes.
In 12(1), there will be those instances, and in
No, I'm
yes.
talking about, because you keep referring to the investigation process in terms of Section 5. That must ultimately end up with an offer.
Yes.
And then an intention to expropriate must also include the offer. Now, both of those provisions, the offer contemplates what is set out here. Is that not so?
In terms of the mechanisms of determining what compensation would be given, yes.
Yes. So both of them take into account this provision. And so we stuck at the same place that I'm asking about. I'm not asking about process. I'm asking about principle.
Yes.
In both processes, we're talking about the applicability of subsection 3. And my question has not been answered, because I'm asking about the principle of offering this landowner, of conducting an investigation and then concluding this person still falls within this provision. They might be hit by the no compensation.
Yes.
And still at section 7, notice of intention to expropriate. So I'm just asking about the principle. How does the owner, the recipient of this offer, at the end of an investigation, yes, I understand what you're telling me. There is an investigation process, and there is an intention to offer. Is the answer perhaps that unless the person, by the end of the notice, by the end of the process, unless that person has gone through this process of objecting or mediating in court, then it is determined. It's determined against them. The solution really, in terms of the act, is that you have to object
yes.
to go to court.
We're taking it even far much more. That's why I kept on humping on Section 7. Maybe let's revert back to Section 7, because it would not happen that only at the time when, or that he might not know that, his property is being targeted. And I think that was the gist of the question. But I'm saying, we are submitting that would not be doing justice to the inherent scheme of the Act. May I invite?
I'm so sorry.
Yes.
When I keep saying about knowledge,
Oh, yes.
I'm talking about as a class of owners who are hit by that provision.
Yes.
I'm not talking about knowledge when you receive a notice, but the question is about the potential that any person who is hit by sub A may be hit by this process.
Yes.
And your answer, it seems to me, is that there's a long process. But that's process, that's the how. I'm asking about the what. How do I know I'm in that category?
Yes. May I invite the judge for us to go to Section 7? And then it's either maybe I am misconstruing your answer or I don't understand it. But I think that a principle and a question that you're asking, the answer is located there, because Section 7.1 says that if any expropriating authority intends to expropriate, it must serve a notice of intention to expropriate on the owner, mortgagee, and holder of a right known to it at the time. So we know that here it's still at the notice stage, not even yet at when they're determining, whether it's going to get any recognition or not. Then B says, then what must follow? They must be published the notice of intention to expropriate under Section 22.2. A notice of intention to expropriate must include, then it tells you. That's where you're going to get your information as the landowner. Number one, statement of the intention to expropriate the property, full description of the property, a short description of the purpose for which the property is required. That information is given. The address at which documents detailing the purpose of expropriation may be inspected, and at which particulars of the purpose may be obtained during these hours. Importantly, E, the reason for intended expropriation of that particular property, the intended future date for expropriation. G, the future date upon which the expropriating authority intends to take possession of the property. H, that is important, an invitation to any person who may be affected by the intended expropriation to lodge with the expropriating authority within 30 days after the publication of the said notice. Then we come to any objection to the intended expropriation, any submission relating to the intended expropriation. And I'm saying then that process cannot be ignored. Then must go over the page to K, an offer of compensation which the expropriating authority considers just and equitable, and an explanation on how the amount was arrived at with reference to the supporting information. So I'm saying the answer lies much more in the scheme of the Act, in the process, and how there'll be engagement from that time with the owner of the land. And the question that is being raised at A is then the question that must reference those preceding sections, and that's how I understand will be the full answer to the question that you've posed.
So this owner would receive a notice saying your property there's an intention to expropriate it, and the purpose or the reason is that it falls within section 12(3)(a). And we're offering you compensation on the basis of that provision. Am I wrong? That's the information that would be included in that offer, not so?
Yeah, but
I'm summarizing the offer. I know that you include all the other items you mentioned, but
and they're critical. That's why it's not easy to say you are right or you are wrong, because then we might be missing each other on a very critical aspects of the act. And that's exactly what we don't want the public to labor under, to say that one can in isolation look at this tray without what we're trying to do in the morning. And so
I really am. I'm not trying to be facetious.
No,
I'm
I
trying
understand.
to understand.
Yes.
I have heard you talk about process, and I'm trying to practically understand what it means, what you're describing, because it seems to me I'm probably missing something. Because what I understand from your explanation is that person, whoever they are, okay, they're going to receive this intention to expropriate, and it tells us there must be a reason, a short description of the purpose and a reason. Both of those things point me to what is itemized in 12(3). Amongst all the other things that are mentioned there, but that information surely needs to be there. 12(3)(a). So your property fits within 12(3)(a). This is why we're offering you nil compensation. Am I wrong?
To the extent I agree with you that if you have regard to K, section
Yes.
7K, and I think that's why we have to go to locate the answer. It
Yes.
says that an offer of compensation which the Expropriation Authority considers just reputable, and an explanation of how the amount was arrived at with reference to supporting information. So he will be knowing at that early notice stage,
Yes.
definitely, he will be knowing about that, because I thought that the gist of the question was that he's just going to be hit with it at the time, whatever thing. But if we agree that as at the time when we now come to 12(3)(a), there would have been those other processes with a full knowledge, with him also having the right to request information, the right to object, then I agree.
No, I accept that.
Then I
Because
agree,
section 12 is not about, it's not really about the time process.
No,
It's about
definitely.
how you determine.
How to determine it,
Yes,
yes.
exactly.
Yes.
So, then my question remains though, and before I ask the question again, this offer here, I accept that in section 7(2), K, the offer might start at a higher level. I accept that. It might start at whatever the level is, and through the application of the relevant considerations go down or up. I accept that. But what you have not answered, and that's where I started, is I understood the challenge to be about the principle
The challenge is
of
that,
being in the category.
yes.
Because by the time the intention to appropriate, that notice comes, you're already in the category. And so when that notice comes out, you're on the back foot, as it were.
The challenge is located on page 001, -150.
150,
Yes, 150.
pleading.
Is the pleadings of IRR.
Don't ask me.
What does it look like? Which one?
What's the bundle number in AfriForums?
Is
6.
it
Number? 1 of 9 is the last one. Sorry?
No, that's the AfriForum.
Yes.
Oh, is it? Oh, yes.
Isn't that the AfriForum matter?
Was it under the heading third challenge?
Right. 001.
001-150. That's where it starts at paragraph 50.
Yeah.
And I think the sting of the attack or the constitutional challenge is framed on paragraph 52 on 001-151. And this is now at the back of IRR having informed the court that meal compensation is competent under section 25(3). That's how we also must understand the challenge. Now, at 52, IRR says, IRR legal agrees with the position set out by AfriForum. Over and above what has been raised by AfriForum, IRR legal submits that this subsection and this subsection and the subsections that flow are irrational and unconstitutional for want of compliance with section 25(2)(b, read purposely with section 25 as a whole and with section 36. 53 says section 25(2)(b of the Constitution provides that an owner of the property may only be expropriated of their property subject to compensation, which is then determined in accordance with section 25(3) of the Constitution. Contrary to this right contained in section 25(2)(b of the Constitution, section 12(3)(a of the Expropriation Act provides that an owner may receive nil compensation simply because they own land and do not intend to develop land or that land or use that land to generate income. That's how we understand the attack. But that attack in oral submission, we are told that they agree that section 25(3), one can then locate a nil compensation within that. Maybe that's why I was struggling to deal with the question of the court, because this is the challenge that we had to come and meet, but that challenge as well, we now know that we don't even have to go anywhere else if the concession is that in terms of 25(3), one can still justify the compensation. The only question is that question of whether or not, and it's the one that I was trying to answer from Justice Saldana, that maybe then, it appears as if it targets those individuals that are keeping property merely for speculation. But the answer is that there may be those people having land, keeping land for speculation, whereby the government might not be needing to use that land for any other purpose related to the act, and therefore their property would not be met by any expropriation.
Could I just follow up from that, Mr.?
Yes.
So, land reform is an ongoing process. Today, it might not be required for land reform.
Judge Saldana?
Land reform is an ongoing process.
Yes.
Today, it might not be required for
Yes.
land reform. But in a year's time,
Maybe.
a administrator identifies it as land that must be considered for expropriation for land reform.
Yes.
Is that not simply the uncertainty about all land in the country that is liable or would possibly fit into any of the categories here?
It is true, but up until such time that then the court will deals with a specific challenge of an owner, bring it to court with the facts, and at the time, that might enrich our jurisprudence, and then challenging it on those basis of the facts, then one understand. But now we can all speculate because we are dealing with this hypothetical challenge, and I appreciate and understand the question. But yes, a land that might not have been determined now, it doesn't mean that in the future might actually be one of the lands which might be required for land reform. But also, that will only be done within the ambit of the law, within what ought to be considered, and testing whatever conduct with the section in the Constitution to see whether is it inconsistent or consistent with it, and the court will be at large then to deal with them on those bases.
But the same piece of land may be subject to successive court challenges, theoretically, because it might not be just and equitable today, but in 2 years' time they might try again on the just and equitable, and then there'll be a further challenge. But that's the uncertainty of it.
But unfortunately, then, Judge, you might not even have to deal with those situations, which we are now contemplating, because they don't locate themselves within, the constitutional challenge, whether or not, by looking at Section 3A as it is, whether it offends any provision of the Constitution. But we appreciate and we agree readily that there may be a number of issues and factors that might only be that might become only evident once the Act is in operation and there are genuine challenges. One cannot be able to offer any answer at this stage. But an answer that we are most certain that we can offer is the one in relation to the challenge and the fair reading of Section 12.3a, and to say the mere fact that there might be that land that's being targeted in order for land development and in the public interest, whether, if you look at 3A as it is, whether does it offend 25. But we also that must ride on the concession that 25.3 nonetheless can locate itself within 12.3 to a nil compensation. Judge, I'm told that you are on injury time. I am just about to go to Section 12.3b.
You covered. You may proceed. Thank you. No, I just wanted you covered on the issue. Are you going to go to the next?
Yes, I'm going to 12.3b.
Yes. Thank you.
I will try to deal with it as quick as I can. 12.3b provides that where an organ of state holds land that it's not using for its core functions and it's not reasonably likely to require the land for its future activities. In that regard, and the organ of state acquired land for no consideration, we still don't understand the unconstitutionality of this, whereby the state itself says that in those instances where the land was not even obtained for any consideration and where it's not going to be used for any of the core functions, why wouldn't that be an appropriate case where a nil compensation can be offered? We're dealing with it much more neatly from page 020, page 159. of our heads of argument. Maybe from paragraph 2 to 7, because the others are simply defining how we define the core functions. At 2
So
to
what
7,
paragraph are you understanding?
2 to 7.
2 to 7, thank you.
Section 12. We say that section 12, 3b does not deprive organs of state of compensation automatically. It only permits nil compensation where the amount is just and equitable after all relevant circumstances are considered. IRR examples concerning universities, academic institutions, or public entities do not establish invalidity. In any real case, the institution's mandate, current needs, future plans, and acquisition history would be considered, and that's the point that we're making, would be considered. The provision gives effect to a legitimate public purpose, which is the rational use of public assets and avoidance of unnecessary compensation of land already held in the public domain at no cost. And therefore we submit that we don't understand, if you read that section, which section of the Act, of the Constitution does it offense, and we are saying that that challenge ought also fail. Justices, I'm told that it's 3:30. We had made a request to leave at 3:30. Would this be an opportune time to adjourn?
It's on that point, so at the University of the Western Cape, for many years there was a piece of land that was earmarked as simply, it was almost a green field. It was a conservation piece of land. But the university's business is not conservation, but it fell within the university's acreage. What the expropriating authority says, we want to expropriate that piece of land.
No.
You got it for free, but it was meant for conservation.
Yes.
It's part of your university.
And
And
that's
the
what,
university now regards it intrinsically as part of its land
yes.
with the conservation, because it does all sorts of horticultural experiments and conservation experiments. But 10 or 20 years ago, it was hardly envisaged by UWC.
Yes.
It was just surplus land.
I'm laughing because I know the land that we're talking about, and
Yes.
that's my institution
Okay.
that landed me here before you. That will be a factor that will have to be considered. That will be among the submissions and the objections that ought to be considered. And if it's found that after that exercise it's not just inequitable, that land would not. It's just, but the the Act provides with specific guideline, but it doesn't say that is the entire list that ought to be taken into consideration. If those facts are then presented by the university as an objection, or during the engagement of further particulars, those will be considered in order to determine whether ultimately that expropriation would meet the threshold and the test of just and equitable. It doesn't follow automatically that must happen. It does not follow automatically that nil compensation must be. But we are saying that let's read the Act within the context of other provisions, and let's give meaning to what the legislator wanted to achieve, merely when it comes to methods and mechanisms of computation.
Thank you, Mr. Mokoena. It's your alma mater that needs to be expropriated. But thank you. We not just need to agree in principle of how many more days we need, so that we can sensibly then you can look at your diaries. Mr. Mokoena, are you?
Judge, from our side, we are saying, a safe number might be 5, so that we don't.
Pardon?
It might be 5. So that
You see, I almost jumped out of my skin.
Justices, this is to avoid a situation where it may be that we don't use the entire 5, but it's a safe number to ensure that all the arguments are heard within that 5 days. The problem in underestimating the number of days is that we might find ourselves in the same situation and then having to look at other future dates. So a safe number, it might also be 5, but it doesn't mean. It means also we might have to deal with the weighing of interest and also whether it will be nil. It won't be nil in this regard, but it might be around 3 or 5.
Who's proposing 5? You just get a sense.
And I can't go against the emperor.
Emperor, you are saying 5? You want to spend another week with us in Cape Town?
We actually had an informal talk yesterday. Actually said it can never be less than 4 to 5. When we actually sitting with the council. So I think 5
is
for the
excessive.
same reason that the management is suggesting. So that we don't get the same problem.
No. Wow. If we were disciplined, can we do it in 3 days?
Yes.
I'd hoped 2 days, but when I got a sense from my sisters, they said you have to be realistic.
It's a fair number.
And at 3 days,
I
is 3
hear
days
support. I hear support.
is 3 days more manageable and sensible?
I plead for flexibility because the remaining sort of supporters of the Expropriation Act, if my reading is correct, there are still about 4 or 5. People are literally going to stand up and speak. I can't guarantee that when I do end up speaking, it will take less than until lunchtime if I start in the morning. But there is an added factor. My learned senior here, Mr. Mkwena, is not done yet. When he emerges from his long holiday to come here again, he might have another day or another fairly long time. And that's because of, obviously, the nature of the case, aside the public interest in the matter, is complex. It's an important piece of legislation to get right. And so I think that the 3 days, and I have a feeling there are big replies coming, because contrary to one of our colleagues who sought to detect a 5-page judgment, it's clear that this case raises more than just 5 pages of issues. It's also clear, now perhaps the focus cleared to the applicants themselves, that the road ahead is not as easy as they thought it was easy from what has been submitted by the others. So I plead for flexibility. I understand that we may end up giving the respondents too much time than they actually deserve. The applicants in their reply. But I think 3 days with 5 speakers still to speak.
But we have the amici, and the amici are limited as opposed to the respondents that have covered a wide range of issues. But
The only
amici-
difficulty, Justice Saldana, is that the amici who spoke earlier on were not regulated in terms of the time that had been allocated. Our reading of how the amici argued was that they are really not amici. They are supporting applicants. It's just that they did hide behind the banner of
Well, the
being
same
amici.
could be said of the
No, it's fair enough.
the amici for the respondents.
For the respondents. So that's a
hiding
new term now.
respondents. So can
But-
we agree on 3 days?
Yes, I'm suggesting that we agree perhaps on 4 days. Because I think we're going to need 2 days for for the respondents to finish their arguments, and only a day for the applicants.
Yeah. Can we just adjourn for 2 minutes?
Judges, I'm sorry.
Yes, Ms. Pillay.
May I address you please for a moment? I wouldn't be one to extend this hearing any longer than it should be, but I would like to support the submission that 3 days is definitely not going to be enough. And I fear that the concern is that there's been unlimited time given to certain persons who have argued, or all the persons who have argued thus far, and there's going to be a similar demand going forward. So my suggestion would be one of two options. Either we settle as a via media on 4 days, alternatively the parties engage on their own WhatsApp group and try and come up with a reasonable slot for everybody, and based on that we revert to the court on the maximum number of days. Thank you.
We'd like to get a sense here today of at least the number. Otherwise, you're going to not have a consensus.
So judges,
You happy with
from our side,
useful?
our proposal would be 4 days if the case to do so. Thank you very much.
Sorry,
Yes,
just-
Mr.
Just very briefly, for some of the parties that aren't litigating the state funds, it's becoming a very expensive proposition, and it seems to us that 3 days would be sufficient. 4 days, it's fairness and equity to everybody. Really, then that means time limits.
Thank you, Mr. Bosler. Mr. Wenger.
Yes, thank you, Justices. This morning I thought that 3 days would be sufficient, but we're not halfway through the respondents. Mr. Duplessis and I kept more or less to our times, but some of the others did take a bit longer. And for that reason, we will need a sufficient time to reply. I'm just concerned that the respondents take another 2 days, and we cramped into a very short time, and on the last day, replies on important issues. So, whereas I thought this morning 3 days, I'm no longer sure that is sufficient, unfortunately.
Mr. Duplessis.
Justice, my learned friend said he kept to the time period, but he didn't. I was the only one who kept to the time period.
Absolutely.
And I have to make up for that in the reply. So I would say, if one argues between 3 and 4 days, let's be safe and do 4 days.
Seems to be an emerging consensus on 4 days. I seem to be the only one out. Even my sisters agree on 4. So perhaps 4 is it, Mr. Mokoena?
Yes, 4 days.
So can we leave you with 4 days, and amongst yourselves, look at your diaries for 4 consecutive days in the 4th term, and preferably, yes, just give us 4 days, and we will then come back with 2 sets of 4 days, and we will then come back to you looking at our diaries to see which one is the most appropriate for us. Can we say that we really do not want this case to go into 2027? So please, let's see if we can find one another in the last term.
We'll try to do that, definitely.
So, as long as it's not the last week of term, because the last week of term we have to do what is called mopping up of civil and criminal matters.
We'll take that into consideration.
Emperor, are you with us? 4 days?
Submitting for this. But with due respect, Honourable Justices, I just don't think it will work based on the trend that we've had in the past.
Yeah. Well,
because maybe to revert back to say, less rather safe and sorry, as my learned friend already said. 4 5 days, if we finish Kenya.
Emperor, I think we have a consensus of 4, and I will commit to my 2 sisters once again that I'll say nothing. I won't ask any questions. But I will break that commitment. So, 4 days. Amongst yourselves, look at your diaries. Is there anything else? Any other housekeeping?
No.
Are you still on your feet?
No, I'm not. I thought that there must be somebody standing up when you're addressing the court. But
Or you'd be surprised, right? You've been standing up the whole day, so. Good. So that brings us to the end of this 5-day session. We started on Monday, optimistically that we would finish in 5 days. Quite real. The matters appear to be complex. Everybody agrees on that, and so we want to ensure that everybody gets the opportunity of expressing their views and their clients' views on these very important issues. And we really appreciate the fact that you've been willing to engage with the court robustly, philosophically. Sometimes we get off the script, but it's important that people understand that we as the court, are also having to debate these issues in a serious way with yourselves. And that's what we've appreciated for the past 5 days. And so to all of you who've been patient listening to the debate with the others, and you're wondering why has that question been asked, sometimes we're not too sure why the question has been asked. But who knows, it might help us when we eventually get to think long and hard on this matter. So thank you to those who are traveling to out of town. If you're not staying for the rugby, you see, Mr. Mokoena, you didn't factor that in. Some need to get to the rugby. Thank you very much for being with us, and those who spoke today. And where's Ms. Zikalala? Thank you very much for your engagement with us this morning, and Ms. Hofmeyer again for your short stint, and Mr. Mokoena. I'm sorry we've had to have the sit and throw and this debate, but thank you for your patience with us. To all of you, thank you for your patience with the court, and we hope to see you again in the first term, safe and sound. And to everybody else who's been present, who are not part of the legal teams, there's members of the public and there's legal teams. We thank you for just being present. And then, of course, to the press, you're really the window to the rest of the world on these debates. For the public, we think it's important that the press is able to show to the public how hard and complex these debates are. And there's the rhetoric, and then there's the complex debates. And we hope that we've been able to reflect the complexity of those debates over the past couple of 5 days. And it's important for the public that we're serious about talking about public interest and public purpose. So we don't take for granted the fact that you've had to sacrifice 5 days of your time to spend with us. We think it's important. Each one of you. Thank you. So all of you, thank you, and we are adjourned.